hi guys, this is 𝗙cie Balakrishna from lecturepedia.in. How are you? Hope you people are doing well. Even I am fantastic. Now, from the today's class, we'll be discussing self-paced online module set A, complete set A, that is corporate and economic laws. I'll be discussing in these fast track lectures. I'll be uploading all these fast track lectures of set A of self-paced online modules for free of cost on YouTube. Okay, so uh, in the today's video we will be starting with the Companies Act first of all. Okay, firstly we will complete the discussion of entire Companies Act, then we'll go for economic laws. Fine. Yeah, now if you see in the Companies Act till section number 148, you'd have discussed, you'd have covered at your intermediate level. Now from section number 149 we'll be covering at CA final level in your set A. Now if you see here in our syllabus, the first 3 chapters of this self-paced online module set A consist of chapters that are related to directors. Just a second. So first 3 chapters are related to directors. You can say these 3 chapters are very much important for examination as well. Around 20 to 30 marks weightage you will be getting from these 3 chapters. You can say 30 marks weightage will be there for these director related chapters. So now here in this class we will be covering the first chapter related to the directors, which is appointment and qualification of directors. Before entering into the chapter, let me first of all give you a brief idea with respect to director. So who is a director and why a director is necessary for a company? Now if you see, broadly speaking, there are 3 ways or 3 formats of doing business, right? One is sole proprietorship, that is proprietor concern, and the other one is a partnership format, and the other one is corporate format or the company format. Now if you see in the sole proprietorship, owner will be the single person who has invested his amount and he himself will manage the business. So the person who the owner himself will manage the business in case of sole proprietorship, and the same is the case even in case of this partnership as well. In case of partnership, 2 or more people will come together and they will invest in a business, and those partners, they themselves will manage their business. So in case of sole proprietorship and partnership, the owner and the person who manages the business are same. Okay, whereas coming to the company, in case of a company, owners will be shareholders. So shareholders will invest their money in the company, and if you take public companies, there will be thousands of shareholders. If you take listed companies, there will be many shareholders. Now if the company has to be managed by all these shareholders, it is impossible. Okay, all these shareholders, they cannot come together and take the day-to-day decisions of the business related to the company. So here in case of a company, what they will do is, on behalf of shareholders, to manage their business, directors will be appointed. Okay, sorry. So here directors are appointed by shareholders. Why? To manage the business of the company. So that is the purpose of directors in case of a company. And here if you observe, in case of a company, ownership is different from management, right? Company's business is being managed by directors, whereas directors are not the owners of the company. Okay, shareholders are the owners of the company. Hope this point is clear to you. Now, with respect to the duties of this director, first of all, how these directors will be appointed, what duties they will do, okay, and how these directors can be removed, what are various types of directors, all these aspects, and how much remuneration has to be given to the directors, all this has been prescribed in the Companies Act. So the first three chapters that we will be covering will be related to these directors. Okay, I hope you got a idea of directors and the necessity to have the directors in a company. So if you see the name of the first chapter, it is appointment and qualification of, sorry, I have by mistake I have wrote as auditors, please correct it as directors. So appointment and qualification of directors. Okay, in order to appoint a particular person as a director, certain qualifications has to be possessed by such person. So what are those qualifications? All these basic aspects with respect to the directors will be seeing in this first chapter, right? And in this first chapter we will be covering from section number 149 to section number 170, almost 23 sections we will be covering here. Okay, yeah. So starting with section number 149. Now if you see section number 149, there are 13 subsections. Okay, now in these 13 subsections, first three subsections deals with basic provisions with respect to directors. Okay, so section number 149 subsection 1 to section number 149 subsection 3 deals with basic provisions with respect to the directors, and section number 149 subsection 4 to section number 149 subsection 13 deals with independent directors. This concept of independent directors, it is basically a huge concept. You cannot understand this concept of independent directors if I tell you now. So what I have done is, we will be discussing this concept of independent director at the end of the chapter. Okay, after discussing all the provisions of this first chapter, then we will cover the independent director. Okay, so now in section number 149, out of 13 subsections, we will be discussing the first three sections here, first three subsections here, and the remaining subsections with respect to the independent directors we will be discussing at the end of the chapter. Okay, now, so section number 149 subsection 1, what this subsection 1 says, basically subsection 1 says that director must be an individual. What is this? Why act is saying that director must be an individual? Now if you see, why you are appointing a director? You are appointing a director to manage business of the company. That means decisions will be taken by the director. Okay, right? Day to day decisions will be taken by the director to conduct the business of the company. So if you have to take the decisions can be taken only by human beings, only by individuals, right? So director must be a individual, right? You cannot appoint another company as a director, you cannot appoint a partnership firm as a director, okay, you cannot appoint a LLP as a director, because LLP company, these are artificial persons, they cannot take decisions. Only individual can take the decision. Since director is appointed to take various business decisions, director must be individual. Okay, this point that director must be an individual is said in section number 149 subsection 1. Hope you understood why director must be an individual. And section number 149 subsection 1 also says the minimum and maximum number of directors. Basically, in a company, minimum how many member of directors has to be there, and maximum how many directors can be appointed. Even this minimum and maximum limit is also prescribed by the act. Now if you see, starting with the minimum number of directors, the minimum number of directors that the company should have is basically, it will vary based on type of the company. If the company is a private limited company, then minimum 2 directors must be there. If company is a public company, then minimum 3 directors must be there. If company is a one person company, then 1 director is enough. So this is the minimum directors that has to be there in the company. Okay, private limited company 2 directors, public limited company 3 directors, and one person company 1 director. These are the limits that have been specified by the act itself. Now coming to the maximum number of directors, act says that a company can have maximum of 15 directors. Hope that is clear. These are the minimum limits, and 15 is the maximum number of directors that the company can appoint. Now the question that arises is, if company wants to appoint more than 15 directors, whether the company can appoint or not. The answer is yes. The act has provided a feasibility wherein if company wants to appoint more than 15 directors, it can do so by passing a special resolution in the general meeting. Okay, maximum directors that has been prescribed by the act is 15, but the act says that if any company wants to appoint more than 15 directors, then you have to then you can appoint such more number of directors by passing a special resolution in the general meeting. Hope that is clear. So that is with respect to the maximum number of directors. Coming to the minimum number of directors, now let's say there is a company which is a private limited company, let's say A Limited. Now as per the act, minimum number of directors that has to be there in the A Limited is 2, right? Here with respect to minimum limit also, act provides a feasibility wherein if company wants, company can increase this minimum limit. Okay, let's say A Limited wants to appoint minimum 4 directors. Okay, it can do so. Okay, if the articles of association of A Limited prescribes that the minimum number of directors that the A Limited should have is 4, then act limit will become invalid. Okay, act has said minimum 2. If company wants, it can increase that minimum limit, but it cannot decrease that minimum limit. Okay, act has said that minimum 2 directors must be there, but A Limited, it cannot write in its articles in its articles of association stating that minimum 1 director is enough. No, act has strictly said there must be minimum 2 directors. You cannot reduce this minimum requirement, but you can increase this minimum directors requirement. Hope that is clear. So this is with respect to minimum and maximum number of directors. However, this concept related to maximum of 15 directors is not applicable to government companies and Section 8 companies. Okay, that means if a government company wants to appoint more than 15 directors, then it can happily appoint without passing a general meeting special resolution, right? Because there is a exception for government companies and Section 8 company. Hope that is clear. So the next concept is that only just now I have discussed now. Can AOA provide for different limits of directors? The answer is yes. AOA can provide for different limits of directors. With respect to minimum limit, AOA can increase the minimum limits of directorships, but it cannot reduce the minimum limit. See, AOA limit can't be less than the act limit. Whereas coming to the maximum limit, if AOA provides for a maximum limit, then act limit has no relevance. Okay, act has told that maximum directors a company can appoint is 15 directors, but the AOA of a particular company, let's say B Limited, provides that in our company maximum there should be 7 directors only. In this situation, since the AOA has provided a maximum number of directors in its company, the act's limit will become irrelevant. Okay, even though act told that maximum 15 directors can be there, since AOA has reduced that maximum number to 7 only, the AOA has to be followed with respect to that company. Hope this is clear. So this feasibility has been provided in the Companies Act with respect to maximum and minimum number of directors, right? So the basic provision, section number 149 subsection 1 says certain points. What are the first one? Director must be individual. Next, minimum and maximum number of directors. And section number 149 subsection 3, it deals with resident director. We'll discuss that resident director, but before discussing resident director, there is a concept of women director. Now, what is this women director? Basically, Companies Act has introduced this concept of women director in order to bring a diversification in the decision making. Okay, in order to encourage women participation in the businesses and in order to encourage women participation in the companies, this concept of women director has been introduced, and also to introduce a diversification at the board level. Okay, at the board of directors level, to have a diversification among men and women, this concept of women director has been introduced. Now, what this concept says, first of all, this women director is not applicable for all the companies. Okay, it is applicable only for listed company. Okay, every listed company, in its board of director, in its board of directors, there should be at least one woman director. Okay, and also other public company having paid up share capital of 100 crore or more, or turnover of 300 crore or more. Even those public companies, apart from listed companies, those public companies which are having paid up share capital of 100 crores or more, or turnover of 300 crore or more, these types of companies should also have at least one woman director in their board of directors. Hope that is clear. Now, I guess you have an idea about board of directors, because this term I will be using quite frequently in this Companies Act. I will just give you a brief idea of board of directors. Basically, director means a single person. Okay, the single director, you will call him as director. Now, a company will not have only one director, right? There will be 2 or 3 directors. Okay, 2 or more directors will be there. Now, all these directors taken together, will call them as board of directors. Hope that is clear. Now, the board of directors of all the listed companies and board of directors of public companies whose turnover is 300 crore or more, or whose paid up share capital is 100 crore or more, must have at least one woman director in their board of directors. Hope that is clear. This is the applicability of women director. Now, yeah, so this is the applicability, and the minimum number of women director is at least one woman director is required. And let's say the company has appointed a woman director, and if the office of this woman director becomes vacated, how to fill that vacancy? See, filling vacancy, it will be filled by board of directors. What is the time period within which you have to fill the vacancy of woman director? You have to fill the vacancy of woman director not later than next 3 months, or the next board meeting, whichever is later. See, immediate next board meeting, or 3 months from the date of vacancy, whichever is later. Let's say, for example, on 1st April 2024, there has been a vacancy created in the office of women director. Now, this vacancy has to be filled by obviously board of directors. What is the time period within which this vacancy has to be filled? within next 3 months or by the time of next board meeting, not general meeting. Let's say for example, the next board meeting is to be held on 30 May 2024. This is the next board meeting date. Let's say this is the next board meeting date. So the vacancy of women director has to be filled within next 3 months or the date of next board meeting, whichever is later. Now in this situation, which will become later? Board meeting is 30 May 2024 and 3 months from 1st April 2024 turns to be April, May, June, right? So 1st June 2024, not 1st June, 30th June, right? 30th June 2024. This is 3 months from 1st April 2024. So which becomes later? 30 June 2024 becomes later. So by 30 June 2024, the vacancy of women director has to be filled. Hope this is clear. Yeah, that is the concept of women director. Basically, this women director has been introduced as a proviso to section number 149 subsection 2. Okay. Yeah. Now moving to section number 149 subsection 3, which is resident director. Now what is this resident director? First of all, the concept of resident director is applicable to every company, whether it is a public company, whether it is a private company, whether it is a section 8 company, whatever the type of company it might be. The concept of resident director is applicable. Now who is a resident director? Resident director means a director who has to stay in India for at least 182 days in the current financial year. Okay, so every company must have at least one resident director. That means at least one director must stay in India for at least 182 days or more in the current year. Why? Because director has been appointed to manage the business of the company. The assumption of the Companies Act is that if director stays in India for at least 6 months or more, then it can be assumed that he is properly involved in the decision making of the company. So 182 days means 6 months. So at least one director must stay in India for at least 182 days or more. This is concept of resident director. So every company must have at least one resident director. Hope that is clear. Now a question arises. Let's say company has been incorporated in the middle of the year. See, generally 1 year will have 365 days, right? So out of 365 days, at least one director must stay in India for 182 days or more. Now what if company has been incorporated in the middle of the year? Let's say company has been incorporated on some 30 September 2024. Now in this situation, the company itself is in existence for less than 365 days. Roughly here you can say around September, right? Let's say 6 months, 180 days. So here roughly I have made that calculation. So here company is in existence, sorry, not 180 days. April, May, June, July, August. Yeah, 180 days. Yes, 6 months, right? So company itself is in existence for 180 days only. But the concept of resident director says that at least one director must stay in India for 182 days. How will it be possible if the company itself is in 180 days? Itself is in existence for 180 days. In this situation, the requirement of resident director has to be calculated on a proportionate basis. That means for 365 days, he has to stay in India. Hey guys, since you are listening to this class till this point of time, I hope you are finding law classes very much engaging. Now, just like law classes for CA final, we are also having audit classes available on our website lecturepedia.in. Now if you see at CA final level, most of the students will fail because of this audit subject, because since audit is a theory subject, people will feel difficult to remember it and they feel boring. Now in order to make this audit subject engaging, we have started teaching audit subject with the help of PowerPoint presentations. If you see these PowerPoint presentations, they are very lively and very engaging. I'll just show you some of the sample presentations that we'll be using in our class. If you see, this is the PPT of SDG and ESG. You can find engaging images that are relevant to the content. Like this, for each and every chapter we will be using PowerPoint presentations. With the help of these PPTs, we will be discussing concepts in the class, and the same images that you find here, they'll also be available in the audit concise book that I will be giving you. Along with the classes, you will be getting this colorful concise book. This is a concept book that we will be using for audit in our class. See, the images that you find in the PPT is the same images you will also find in our books. And along with this audit concise, which is a concept book, you'll also be getting question and answer book. Even this question and answer book, it is a completely color book. And both in question and answer book and concise book, you will be finding the key terms highlighted in red color. Okay, so if you wish to purchase these classes, you can visit our website lecturepedia.in and you can place your order. Now you can continue listening your class. Out of 365 days, he has to stay in India for 182 days. This is the basic requirement, but company itself is in existence for 180 days only. In this situation, for how many days he has to stay in India to call him as a resident director? You need to simply cross multiply 180 into 182 by 365. Let me take a calculator here. Okay, whatever the number you arrive here, I guess here you will get some around 90 days, because it is half, right? So I have made a rough calculation. You can just calculate it in your calculators. So if the company is in existence for less than 365 days, then the requirement of resident director, you need to calculate on a proportionate basis. Hope that is clear. So here I have made a calculation for you. You can go through that. And the link to this notes, you can find it in the description, and I'll also be sharing these notes in our Telegram channel. Okay, now, so by that we have completed the 3 subsections of section number 149. Moving to section number 152. Now section number 152, basically 149, the 3 subsections we have covered the basic provisions, right? Now section number 152 deals with appointment of directors. So how the directors will be appointed in a company? Let's see. Here in this section number 152, there are 7 subsections. The first 5 subsections, they deal with appointment of directors. Next, 152 subsection 6 deals with a special concept, that is retirement of director by rotation. This concept, it will be very interesting. We'll discuss that section number 152 subsection 6, and section number 152 subsection 7 deals with deemed reappointment. These two are linked together. Okay, 152 subsection 6 and subsection 7 are linked concepts. So first we'll discuss the first 5 subsections, which is appointment of directors. So here there are 2 processes. Basically, if the first director will be appointed in a different way, and subsequent director will be appointed in a different way. First of all, who is a first director? First director means nothing but, let's say the company is incorporated just now, and you are appointing director for the first time in that company, he will be known as first director, right? And after the first director has been appointed, subsequently in each and every year you will appoint some more directors, they will be known as subsequent director. So the procedure that has to be followed for the first director is different from the procedure that has to be followed for the subsequent directors. So we'll start with appointment of first director. Now company, it will be having articles of association, right? While incorporating the company, you will have a articles of association, memorandum of association, all these documents you'll prepare. Now if AOA has any name of the first director, let's say AOA of a company says that so and so person has to be appointed as a first director. Since AOA is having a name, he will be appointed as the first director of the company. Okay, if in case AOA is silent, AOA has not given any name of first director, but AOA has a process. Okay, AOA has specified a process by which the first director has to be appointed. Let's say for example in the AOA it is specified that all the promoters, they must come together and they have to among discussion among themselves, they need to appoint a director. Okay, that means promoters have to select the director. Like this it is written in the AOA. That means AOA has specified a process. Since AOA has specified a process, you need to follow that process for appointing first director. Let's say AOA has not given a name, AOA has also not having any process. In this situation, subscribers to the memorandum will become the first directors. Basically, if you see in the MOA, there will be subscribers. By paying subscription fee, certain shareholders will join the company, right? So they will become the first directors. Subscribers to the memorandum will become the first directors if AOA is silent. Hope that is clear. So this is the procedure for appointing the first director. Basically, once the company has been incorporated, there will not be any shareholders, right? Since all the shareholders will not be there, so this type of procedure has been prescribed. Once the company has been incorporated, from the next year onwards, the shareholders, they will appoint the directors. If you see the subsequent directors by shareholders, by passing ordinary resolution in the annual general meeting, subsequent directors will be appointed. Hope that is clear. And the tenure of the first director, okay, the first director tenure will be till the conclusion of first annual general meeting. Okay, the first directors will hold their office till the conclusion of first annual general meeting, because in the first annual general meeting, shareholders, by passing ordinary resolution, they will appoint the directors. Hope that is clear. So subsequently in the coming years, every time shareholders will only appoint the directors. Okay, and for appointing the directors, the resolution that is required is ordinary resolution. Hope that is clear. That means more than 50% of votes is required to appoint a director. Now another question. Basically, most of the directors they will be appointed by shareholders only, except certain categories of directors. For certain categories of directors, Companies Act has prescribed certain procedure. Let's say for example, alternate director, additional director, independent director. Okay, so like this, for certain categories of directors, a specific procedure has been prescribed by the act. We will be discussing this in section number 161. In section number 161, there are 4 subsections. All these 4 subsections, we will deal with the different type of procedure that has been provided by the act for these additional director, alternate director, and the nominee director, casual vacancy director. Okay, for these for some categories of director, a different procedure has been prescribed. So except those directors, remaining all directors will be appointed by shareholders in the general meeting by passing ordinary resolution. Okay, so this is the procedure for appointing the first director and the subsequent director. Still there are certain additional requirements for appointing the director. We will see those additional requirements. Now that person must possess a DIN and he needs to furnish it. What is this DIN? DIN means director identification number. In order to appoint any person as a director of the company, that particular person must possess a DIN, director identification number. Without DIN, you cannot appoint such a person as a director. This DIN, it will be given by MCA, Ministry of Corporate Affairs. If you make an application to MCA, they will allot a DIN to you. There are various sections with respect to DIN also. Basically, from section number 152 to section number 157, we will be discussing provisions with respect to DIN, that we will discuss later on in this class itself. Okay. And declaration of non-disqualification. Basically, if you see, in order to appoint a person as a director, he should not have any disqualifications. Section number 164 of the Companies Act has given certain list of disqualifications. If the person possesses any such disqualifications, he cannot be appointed as a director. What are those disqualifications? There is a list of 9 disqualifications that we will be reading in section number 164. So in order to appoint a person as a director, he must not have those disqualifications. Okay. Next, obviously the person should give his consent to act as a director, right? Without taking consent from the person, you can't appoint him as a director. Okay, if that person itself is not willing to get appointed as a director in your company, how can you appoint him? So consent is also required. And once the person gives the consent, company within 30 days it has to file a form with the register of companies, that is DIR 12. This is the form which has to be filed by the company with ROC, stating that we have appointed this particular person as a director in our company. And if in case you are appointing an independent director, what is this independent director? I have not yet explained the concept of independent director. Basically, if you want to appoint an independent director, additional requirement that you need to furnish is explanatory statement. In this explanatory statement, you need to explain why you are appointing that particular person as an independent director. Okay, you need to give explanation. And also the board statement. This independent director, I have told you now, we will be discussing at the end of the chapter. There you will get a clarity of who is an independent director. Basically, the name itself says independent. That means he is not dependent on anyone. Okay, the decisions that this independent director will not have any bias, because he is independent. Why he is independent? The act, section number 149 subsection 4 to subsection 13, has provided various requirements. If the person qualifies all those requirements, only that person has to be appointed as an independent director. Okay, there are a lot of requirements that independent director needs to satisfy, that we will be discussing later on. Okay, so that is the discussion with respect to appointment of director, which is section number 152 subsection 1 to subsection 5. Just a second. Yeah, now moving to the concept of rotation of directors. Now you have appointed the director. Whether this director can continue in this position of directorship for a lifelong, or is there any time period within which he has to retire? The answer is the concept of this rotational directorship. Okay, director cannot continue in his position for lifelong. He needs to retire by this concept of rotation. We'll see that. However, the concept of rotational director, it is applicable only for the public companies. Okay, this concept of rotation of directors is not applicable for the private companies. First of all, let me explain you how this rotational director concept will work. Before explaining this concept, you need to understand two terms. One is, the two terms that you need to understand are rotational director and retiring director. Who is a rotational director? Who is a retiring director? Basically, the act says that now, let's say a company is having in total 9 directors. Okay, total directors are 9 directors. Of these 9 directors, as per Companies Act section number 152 subsection 6, at least 2/3 must be rotational directors. Rotational director means their period of office has to be decided by this concept of rotation. Okay, the directors whose period of office will be decided by this concept of rotation is known as rotational director. Okay, and remaining 1/3 can be non-rotational directors. That means their office can be for a fixed duration of time. 1/3 can be non-rotational directors. So in our example, 2/3 means 6 directors out of 9 must be rotational directors. That means their period of office has to be decided by the concept of this rotation, and remaining 3 directors, their tenure, it can be fixed by the shareholders or based on their appointment. Basically, 1/3 can be non-rotational and 2/3 must be rotational, and this concept of rotational is applicable only for public companies, right? Now, okay, 6 directors are rotational directors. It doesn't mean that all these 6 directors will retire at the annual general meeting. No, the office of these 6 directors is decided by the concept of rotation. Out of these 6 directors, only 1/3 will retire at the upcoming annual general meeting. So only 1/3 will be retiring directors. Okay, now here, out of 6, 1/3 means 2 directors will be retiring directors. Hope you understood the difference between rotational directors and retiring director. If you see, total number of directors are 9. Of these 9 directors, 2/3, that means 6 directors must be rotational directors. Of these rotational directors of 6, 1/3, that means 2 directors will retire at the upcoming annual general meeting. That is, 2 directors will be retiring directors. This is the difference between rotational directors and retiring directors. And these are the limits specified by the act: 2/3 and 1/3. Now the question: act has told that section number 152 subsection 6 told that 2/3 must be rotational, 1/3 must be retiring. Okay, 1/3 of what? 1/3 of rotation directors must be retiring directors. Okay, you should not apply this 1/3 on the total number of directors. No, one third should be applied on the rotational directors. Okay, see how, let me explain you how it works. Total directors, of these total directors, two thirds will be rotational. Of these two thirds rotational, one third will be retiring. Hope you are clear. Now, whether articles of association can provide that all the directors of the company will be rotational directors only, all the directors of the company will be retiring directors only, whether articles of the company can have this type of provision, the answer is yes. AOA of the company can have a provision stating that in our company all the directors will be rotational directors only, in our company all the directors will retire at the upcoming annual general meeting. This type of provision the articles of association can have. Okay, the two-third and one-third is the minimum requirement that the act has prescribed. Okay, next, another point, while calculating two-thirds rotational directors, if you get any decimals, let's say there are 10 directors, total 10 directors, of these 10 if you calculate two-third, you will get something like 6.7, something like that you will get. So here it is decimals, you are getting decimal, you cannot cut the director into half, right? It should be either 6 or 7, he cannot be 6.7, right? So for calculating two-third, you have to always round up, upward rounding has to be done for calculating two-thirds. Okay, if you get 6.2, 6.3, 6.4, you should round it upward. Okay, because the terminology that has been used is not less than two-third. See, rotational director should not be less than two-third. Okay, you have calculated two-third of 10, it has, you got some 6.4, something like that. Now if you take it as 6, it will be less than two-third, but as per the act should not be less than two-third. So you have to always do a upward rounding for calculation of two-third, whereas for calculation of one-third you can round it off, you can either do upward rounding or you can do downward rounding, that is truncation. You can do either truncation or you can do rounding up for calculation of one-third. Okay, because the act has not used the terminology of not less than one-third, it has just told one-third of rotational director must be retiring director. So for calculating one-third, you can do either upward rounding, basically nearest rounding you have to do. Let's say you have got 6.2, nearest to 6.2 is 6. Let's say you have got 6.8, nearest to 6.8 is 7. So you have to either do round up or you have to do either truncation, okay, based on the decimal that you get. Hope that is clear. That is another point with respect to rotational and retiring director. Yeah, now still there is a lot of discussion in this section 152 subsection 6. We'll go further. Now let's say there is a company. We'll be discussing these two, subsection 6 and subsection 7 simultaneously. Okay, the concept that I will be telling you from now, it will be both together I will be dealing. Okay, subsection 6 and subsection 7 both together I will be explaining you. So let's take an example, A limited, or let's say X limited. Now in the X limited there are total 9 directors. Just total 9 directors. This is the total number of directors. Now obviously of these 9 directors, 2/3 must be rotational. That means six directors must be rotational. So here rotational directors are 6, right? Let's say Mr. A, Mr. B, Mr. C, Mr. D, Mr. E, Mr. F. These are the 6 rotational directors. That means their office has to be determined by the concept of rotation. Okay, they have been, let's say, I'm also writing their order of appointment. A has been appointed first in the company. After A, B has been appointed second, and C and D both are appointed together. Okay, after C and D has been appointed, after some 2 months or some time, E has been appointed. After E has been appointed, F has been appointed. So this is order of their appointment. Okay, so here if you see, A is the senior most director because he has been appointed first in the company. After A, next senior is B, next senior is C and D because they are appointed at the same time. Next E, next F. Okay, now their office will be determined by the concept of rotation. See how beautifully this concept will work. Now you'll understand. Now the next AGM has come. See, AGM has come. AGM. Now in the annual general meeting, 2 directors have to retire. Why 2 directors? It is 1/3 of rotational directors will be retiring directors, right? Now if you see 1/3 of 6, how much it will become? 2. So in the annual general meeting of these 6 directors, 2 directors must retire. Hope you are clear till here. Now 2 directors have to retire. Who will be these 2 directors? Of A, B, C, D, E and F, who will retire? There are 6 directors. Of these 6 rotational directors, only 2 directors have to retire. Who will retire? Act says that the director who is longest in the office will retire first. Now if you see here, A is the senior most. That means he is longest in the office. So first A will retire. After A, B is the senior most. B also will retire. So since 2 persons has to be retired, 2 persons got retired in the annual general meeting. Now balance available directors are Mr. C, Mr. D, Mr. E, Mr. F. So total 6 directors have become 4 directors only. Remaining 2 positions, they are vacant, right? Now these vacant position directors, these vacancies have to be filled by the shareholders, right? Now here shareholders, they can appoint a fresh person as a director. Okay, basically if you see here, shareholders are having 3 options with them to fill the vacancy. Options to fill vacancy. What are those 3 options? First one, appoint retiring director himself. This is the first option. Appoint retiring director himself. Here if you see, A and B got retired. If shareholders want, they can reappoint Mr. A and B. This is the first option. Or if shareholder feels that A and B have not done the work properly, okay, they have not taken proper decisions in the company. If the shareholders feels so, they can appoint fresh people. That means new people. Appoint new persons as directors to fill the vacancies. Appoint new persons. This is the second option that is available. third option that is available is keep the vacancy as it is. Keep the vacancy as it is. If the shareholder feels that 4 directors are enough to manage this company, okay, so if the shareholders want, they can keep those remaining 2 positions vacant itself, okay, as it is vacancy they can keep. So these are the 3 options that are available with the shareholders to fill the vacancy. Now let's say here shareholders felt that Mr. A is there na, he has not taken proper decisions during his tenure. Shareholders doesn't want to reappoint Mr. A. So in Mr. A's position, shareholders have appointed, let's say, G. Okay, shareholders have appointed G in the place of A. And coming to the next vacancy, that is in the place of B. Now shareholders feels that B is a intelligent person, and he has taken proper decisions in managing the company, and shareholders are feeling that services or B are required to improve business of the company, so B must be there in the company, like the shareholders are feeling. So in this situation shareholders can reappoint Mr. B again. So they have reappointed the retiring director himself as director again. Okay. Now, so this has happened in this annual general meeting. After 1 year, again another general meeting will come. Right now, in this another general meeting, again of the rotational directors, again 2 directors have to retire. Now who will be those 2 directors that has to retire? The director who is longest in office will have to retire. Now if you see here, who is longest in office, here the problem arises because Mr. C and Mr. D, these 2 directors are longest in office, but sorry, just a second, I'll just change the example. I have told you that Mr. E is appointed after Mr. D, right? Let me change this stating that Mr. E is also appointed along with C and D, okay, and Mr. F has been appointed after C, D, E. So now if you see in the next annual general meeting, 2 directors have to retire, but here 3 directors, that means C, D, E are appointed at the same time. Director who is in the longest in the office has to retire, but here there are 3 directors who are longest in the office, but only 2 directors have to retire. So what to do in this situation? Again there are 2 options that are available. Directors have to discuss among themselves and decide who will retire. Now Mr. C, Mr. D, Mr. E is there now. These 3 directors, they have to discuss among themselves that who will retire, and 2 directors have to come out for retiring. This is the first option. Let's say C, D, E have discussed among themselves and none of them are willing to retire. All of them want to stay in the company itself. Now in this situation what to do? In this situation you should go for a draw of lots. You need to write the names of these 3 directors in paper, and you need to draw a lucky draw, and in that lucky draw whose names comes, they have to retire. So if the mutual discussion among director fails, you should go for a draw of lots. Let's say in the draw of lots, C's name and E's name has come. So C and E, these 2 people will retire, and the remaining directors are D, F, G, B. Again 2 positions are vacant. Now in the place of Mr. C, shareholders have appointed F, not F, H, and in the place of Mr. E, shareholders have appointed I. Okay. Again, in the next general meeting, again the same will repeat. Two directors have to retire. So obviously here, who are longest in the office? G, B, H, I are appointed recently. In the previous general meetings only they were appointed. D and F are longest in the office. So obviously D and F will retire. Remaining directors are G, B, H, I. And in the place of D and F, company have appointed, the shareholders have appointed J and K. So if you see, if you observe, at the beginning A, B, C, D, E, F are directors. After 3 years, complete board of directors have changed. Okay, this is the beauty of this concept of rotation of directors. Okay, if you apply this concept of rotation of directors, within 3 years there will be a complete reshufflement in the board of directors. It is secondary that B has been again appointed, but shareholders have got a chance to decide whether to appoint the retiring director or not, right? So in the span of 3 years there will be a complete reshufflement in the board of directors. This is the beauty of concept of rotation directors. Now why this concept of rotation of directors is important? Because let's say if this rotation of director concept is not there, and you have appointed Mr. A and Mr. B as director of company, now what they will feel? They know that they will not retire because there is no concept of rotation. They can continue in the company as much time as they want. So since they are having this confidence, they will not work properly, their performance will decrease. Instead of this, if let's say there is concept of rotation in the director, there is a concept of rotation of director in the company, and A and B know that if they don't work properly in the current year, there is a chance that shareholders might not reappoint them again. So with this fear, their performance will increase. So this is the benefit of the concept of rotation of directors. Hope that is clear. I hope you are clear with this. So by this we have completed discussion of section 152 subsection 6. Now in continuation to this, section 152 subsection 7, I have told you that this in the same example, let us continue the same example. Here at last J and K are there, na? D and F, they have retired, right? Now the position of Mr. D and Mr. F, they are vacant. Those positions have to be filled by shareholders in the annual general meeting, right? Now let's say shareholders have not passed any resolution to fill these vacancies. Okay, they have also not passed any resolution to keep these vacancies as it is. Basically, shareholders are having three options, right? To appoint a retiring director, or to appoint a new person, or to keep the vacancy as it is. If shareholders decide to keep the vacancy as it is, for this also a resolution has to be passed, because this is also a decision, right? This is also a decision to keep the vacancy as it is. To take this decision, a resolution has to be passed, but no resolution has been passed. Okay, none of the resolution has been passed to fill the vacancy of to fill these two vacancies, and general meeting has completed. Okay, at the beginning of the general meeting, D and F have retired, and the general meeting has completed. Shareholders now have not passed any resolution about those vacancies. Without passing resolution only, the general meeting has completed. In this situation, the meeting will be, okay, the general meeting will be adjourned to next week, same day, time and place. Okay, if the vacancies has not filled by the shareholders and the AGM has completed without filling the vacancies, then the AGM will be adjourned to the next week, same day, same place, same time. Okay, and in this adjourned meeting, let's say in the adjourned meeting also no decision has been taken whether to fill that vacancy or to keep the vacancy as it is. In such a situation, okay, if in the adjourned meeting also no decision has been taken, in such a situation, retiring directors will be deemed to be reappointed. Okay, this is the concept of deemed reappointment. Since in the adjourned meeting also no decision has been taken by the shareholders, it will be deemed that retiring director himself will be reappointed. Hope that is clear. So this is a deemed reappointment of directors, section number 152, subsection 7. Hope you are clear with this concept. So if you see here, you can find the same concept that I have told you. How to fill the vacancy that has been created? The shareholders are having three options: either reappoint the retiring director, or appoint some other person, or keep the vacancy as it is. Now, to appoint a person other than the retiring director, the procedure it is prescribed in section number 160. We'll discuss that section number 160. If none of the above action has been taken in the meeting, then that meeting will be adjourned to the same day, next week, same time, place, and other than holiday. Okay, that day to which you have adjourned the meeting, it should not be a holiday, a public holiday. Okay, if it is a public holiday, it will be postponed to the next day. And if at the adjourned meeting also no action has been taken, none of those three actions has been taken even at the adjourned meeting also, in such a situation, retiring director will be deemed to be reappointed, unless in the following circumstances retiring director will not be deemed to be reappointed. What are those circumstances? If the retiring director gives unwilling notice. Now, director has retired at the meeting, and in that meeting no resolution has been passed. Meeting has adjourned. Even at the adjourned meeting, no resolution has been passed. Now, if at the adjourned meeting no resolution has been passed, the retiring director will be deemed to be reappointed. But here the retiring director is there now, he has given a notice to the company stating that I am unwilling to be appointed as a director in your company. If the director he himself is not willing to be reappointed, then how can you reappoint him? How can it will be deemed that he will be reappointed? So if the director gives a notice of his unwillingness to be reappointed, then deemed reappointment concept will not be applicable in that scenario. Next, the director is disqualified under section 164. I have told you na, in section 164 there are 9 disqualifications. If the director gets hit by any of those disqualifications, in such a scenario also the deemed reappointment concept will not be applicable, because such retiring director is disqualified under section 164. Hope that is clear. Since he has hit by the disqualification, he cannot be reappointed. So deemed reappointment concept is not applicable here. Next, resolution for his reappointment was lost. Okay, either at the actual meeting or at the adjourned meeting, the resolution has been proposed to reappoint the retiring director, but shareholders have not approved the resolution. So that means shareholders doesn't want to reappoint the retiring director. In such a situation, you cannot deem the retiring director to be reappointed. So in such a situation also, section number 152 subsection 7, that is a deemed reappointment concept, is not applicable because shareholders doesn't want to reappoint him. And next, finally, section 162 is applicable to the case. What is this section 162? Let me explain. The next section that we are going to discuss is section 162 only. If section 162 applies, then also deemed reappointment concept is not applicable. Basically, to understand this point, we will be reading three sections together. Section 152 subsection 7 plus section 162 plus section 176. These three sections are interlinked. We will be reading these three sections together. Now I'll explain how these are interlinked. Before going to that, another small point. From the total directors, see, for the purpose of calculating rotational directors, you will take the total directors, right? For the total directors, you will apply 2 by 3, right? 2 by third of total directors should be rotational. So here, total directors, who should be included in the total directors? Basically, certain directors should not be included in the total directors. There are certain directors who has to be excluded from the total directors for calculating the 2/3. So who are they? First of all, independent director should not be included in the total director for the purpose of calculating rotational directors. That means independent director will never be a rotational director because his term need not be determined by the concept of rotation, because he can be appointed for a fixed term. If you see in section number 149 subsection 3 to subsection 4 to subsection 13, we will see the tenure of the independent director will be 2 terms of 5 consecutive years. We will be seeing that. So since there is a separate tenure for the independent director, his office will not be determined by the concept of rotation. So in calculating the total number of directors, independent director will not be included. Next, small shareholder director, section number 151. Yes, section number 151. As per section 151, the tenure of small shareholder director is 3 years. Since there is a fixed tenure for small shareholder director, even the office of small shareholder director will not be determined by the concept of rotation. So you have to exclude him while calculating the 2/3. Next, nominee director. Nominee director means, first of all, who is a nominee director? Let me explain you. Let's say your company, there is a company. This company has taken a huge amount of loan from a bank. Let's say SBI Bank. Okay, some 1,000 crores loan has been taken from SBI Bank. Now, since that much amount of loan has been given to the company by SBI Bank, on behalf of bank, a person will be appointed onto board of directors of this company, because it has given huge amount to this company. It wanted to see whether this amount has been properly utilized. So for this purpose, a director on behalf of SBI Bank will be appointed to the board of directors. Here if you see, this director will be known as nominee director, because he is nominated by some external organization. So he will be known as nominee director. Even the tenure of nominee director will be based on the circumstances. Okay, based on the terms between the appointing organization and the company. So even the nominee director has to be excluded for calculation of this 2/3. Next, additional director. Even the additional director will be having a fixed tenure of 1 year. We will be discussing additional director in section number 161 subsection 2, I guess. Okay, so section 161 subsection 1 is alternate director, subsection 2 is additional director. So the tenure of additional director is also 1 year. So since even his tenure is also fixed, he should be excluded from total directors for calculating 2/3. Next, proportional representation director. What is this proportional representation director? Basically, under this proportional representation director, directors will be appointed by following certain specific methods. The most common method that the Companies Act prescribes is preferential voting method. Preferential voting method. Now, if you see, in this preferential voting method, shareholders will select the directors. Basically, shareholders will give preference of directors. Let's say there are 4 persons who are contesting for the directorship. Now the shareholders will give their preference. Okay, first preference, second preference, third preference, fourth preference, like the shareholders will give the preference. Based on this, the directors will be selected. Since a separate method is being followed for appointment of directors, the concept of rotation of directors is not applicable here also. Okay, so in case you have appointed director by using a proportional representation method, then you need not include such a type of directors for calculating 2/3. Okay, for calculating the total number of directors for the purpose of 2/3. So these 5 directors has to be excluded from total directors while calculating 2/3. Hope that is clear. So by this we have completely discussed section number 152. Now moving to section number 162. Basically, what is this section number 162? Which section number 162 is also related to appointment of directors only. What section 162 says is, now generally, let's say A Limited. Okay, now A Limited wanted to appoint Mr. X as director of company. So what A Limited will do? A Limited, the board of directors of A Limited will make this proposal of appointing Mr. X to shareholders in the annual general meeting. Right? This resolution would be put in front of shareholders by A Limited. Shareholders will either approve the resolution or they will reject the resolution. Let's say A Limited wants to appoint Mr. X as well as Mr. Y. Okay, A Limited wanted to appoint 2 directors, Mr. X and Mr. Y. Now section number 162 says that single resolution should be used for appointing single director. Okay, you have to appoint a director only through a single resolution. Okay, one resolution for one director. You cannot appoint 2 directors in the same resolution. Okay, you have to propose Mr. X separately and Mr. Y separately. Why? Let's say A Limited wants to appoint Mr. X and Mr. Y. Both persons A Limited wanted to appoint. But Mr. Y is there, na? He is a fraudulent person. Okay, shareholders are not having confidence on Mr. Y. If resolution to appoint Mr. Y was is put before the shareholders, 100% shareholders will reject that resolution. A Limited already knows this. At the same time, Mr. X is there, na? He is very good person. Shareholders actually wanted Mr. X to appoint. Okay, so what A Limited will do is, shareholders wanted to appoint Mr. X, but shareholders doesn't want to appoint Mr. Y. So tactically, what A Limited will do is, A Limited will propose appointment of Mr. X and Mr. Y together in the single resolution. Okay, if single resolution is put forward before the shareholders to appoint Mr. X and Mr. Y, then the option available to shareholders is either to accept appointment of both the directors or to reject the appointment of both the directors. Okay, here shareholders are not having option to select one director and to reject another director. Okay, if single resolution is used to appoint both the directors, to avoid this type of situation, what section number 162 says is, you have to use single resolution for appointment of single director. You cannot appoint two or more directors in a single resolution. Okay, strictly only one resolution or one proposal has to be sent for appointment of one director. Hope you understood the background of section number 162. See, general rule: two or more directors can't be appointed through a single resolution. I have told you the reason also. Exception, but there is a exceptional situation in which the directors can appoint, the company can appoint two or more directors in a single resolution. What is the exception? Now see the same example, continuing the same example. Now here A Limited wanted to appoint Mr. X and Mr. Y in a single resolution. Now for this, if A Limited wanted to appoint both the directors in a single resolution, then to do this, A Limited has to first of all ask the shareholders, we wanted to put a single resolution for appointing both Mr. X and Mr. Y. Is that okay for you? Like this, first of all, A Limited has to ask for the permission of the shareholders that A Limited want to put a single resolution for appointing Mr. X and Mr. Y. Now, if shareholders unanimously, okay, unanimously means even one shareholder also should not show any objection for this. Okay, if all the shareholders agrees that one resolution you can put before us for appointing both the directors, if all the shareholders agrees, only then, only in that situation, A Limited can use a single resolution for appointing two or more directors. Okay, other than in this exceptional situation, in no other case company can appoint, in no other case company can use one resolution for two or more directors. Okay, always only one resolution for one director. Hope that is clear. You need to observe that here the approval is unanimous approval. Okay, however, section number 162 is not applicable to government companies and private companies. It is applicable only to public companies. Now, if you see, now I will link section number 162 and section number 152 subsection 7. Now, if you see here, section number 152(7), it says that the concept of deemed reappointment will not be applicable if section number 162 is applicable to the case. What is this? See, previously we have discussed that. Where is that example? Let me take you there. Or else, let me start afresh. See, now, as per section 152 subsection 7, what will happen? The vacancy in the office of director, it needs to be filled by the shareholders in the general meeting. In the general meeting, vacancy has not been filled. Then what will happen? Meeting will adjourn. In the adjourned meeting also, no decision has been taken. If no decision has been taken in adjourned meeting, then retiring director will be deemed to be reappointed. This concept of retiring director deemed to be reappointed will not be applicable if section 162 was applicable to the case. That means, let's say Mr. A has retired in the meeting. and no decision was taken. Meeting was adjourned. Even in the adjourned meeting, no decision was taken. So as per 152 subsection 7, what should happen? Mr. A has to be reappointed, right? Will be deemed to be reappointed as per section 152 subsection 7, because in adjourned meeting also no decision has been taken. Now if we apply section 162 to this scenario, that means applying section 162 means what 162 says? You have to use a single resolution for appointing one director. Here, while appointing Mr. A, at the time of appointing Mr. A, section 162 was contravened. That means single resolution was used to appoint Mr. A and Mr. B. Okay, at the time of appointing Mr. A, two or more directors were appointed with the single resolution only. That means section 162 is contravened. If section 162, while appointing, if section 162 is contravened, the appointment will become invalid, right? So since at the time of appointment Mr. A's appointment has got invalid because of contravention of section 162, he is not a director at all, right? Even though he is not a director, he kept on working as a director because of ignorance. Okay, might be this rule might not be known to him, or whatever the reason might be, because of ignorance he kept on working in the company even though he is not a director. Okay, why he is not a director? Because section 162 was contravened at the time of his appointment. Now in the first case he is not a director, and after retiring, how can he be deemed to be reappointed? He cannot be deemed to be reappointed because he is not a director at all, right? I guess you are getting what I am trying to say. Okay, at the time of appointment section 162 was contravened. If section 162 is contravened, he is not a director. If he is not a director, how can you again deem him to be reappointed as a director? Okay, I guess you got an idea of this. Now you might get a question, sir. Okay, he has been appointed. Okay, two directors were appointed with the single resolution, like that Mr. A was appointed, and due to his ignorance he kept on working in the company. Let's say in the company he has acted as director for 1 year. Now in this period of 1 year he would have taken many decisions. Okay, he would have conducted various business activities of the company. Without being a director, he has conducted all these activities. Whether all these activities will become valid or invalid, see, thinking that he is a director, he has taken all these decisions, and after some days it came to it came to light that due to contravention of section 162 he is not a director, but he has taken various decisions in the past thinking that he is a director. Now what will happen to all these decisions? Whether all those are valid or invalid? The answer is all those actions will become valid because of application of section number 176. Okay, section number 176 will make all the actions that has been done by this person valid. Okay, we will be discussing this section number 166 in the third chapter. Okay, meetings of board and its powers, that is the chapter name. Okay, in that chapter we'll be discussing section number 176. Okay, so section 176 will make will make all the actions that has been done by this person valid even though he is not a director. Hope that is clear. Okay, since 162 has been contravened and because of his ignorance he has done all the activities, you cannot make all the activities invalid, so section 176 will come into the picture and it will make all the actions valid. Hope that is clear. But deemed reappointment will not be applicable because he is not a director in the first scenario itself. Hope you got an idea. So here you need to interlink all these three sections. What are they? 152 subsection 7 plus 162 plus 176. These three sections together you have to read. So that was about section number 162. Now moving to section number 151, which is small shareholder director. What is this small shareholder director? See, in the company, to appoint a person as a director, majority shareholders will be having the power to appoint, basically ordinary resolution. That means shareholders who are having voting power of more than 50%. Okay, if 50% shareholders vote to appoint a particular person as a director, he will be appointed as a director. Now the question is, there will be some small shareholders in the company. Okay, let's say Mr. A, Mr. B, Mr. C, Mr. D. These four people are the shareholders. Mr. A, Mr. B, these two people together are holding some 80% shares of the company, and Mr. C, Mr. D, and remaining all other people, they are holding remaining 20% of shares of the company. Now in this situation, in favor of, let's say, whomever Mr. A and Mr. B wanted to appoint as a director, they can be appointed as a director, right? Just a second. So yeah, so whomever Mr. A and Mr. B supports, they will become a director, and Mr. C, Mr. D, they are also shareholders. They should also be given power to appoint directors. But because of the fact that Mr. A and Mr. B are holding more than 50% shares, they have got entire control for appointing the director. Is this fair? The answer is no. This is not fair. Even Mr. C and Mr. D should be given opportunity. To deal with this type of situation, the concept of small shareholder director has been introduced. Now, to represent small shareholders in the company, a director can be appointed by these small shareholders. Okay. However, this concept of small shareholder director, it is not mandatory. It is just optional. Okay. It is applicable only for public companies. Even in that public, it is applicable only for listed companies. Even in that listed companies also not mandatory. It is just optional. Okay, see, applicability, it is optional. It is applicable to listed companies. There also it is just optional. Now, who are small shareholders? Okay, when will you call a particular shareholder as a small shareholder? See, if the shareholder holds shares of value not more than 20,000 rupees. Okay, this 20,000 rupees is face value, not market value. Okay, shareholders holding shares value of less than or equal to 20,000 face value will be known as small shareholders. This is a definition of small shareholder. Now, this small shareholder director can be appointed either suo moto by the listed company. Okay, if the listed company, the company itself, if it feels that there are many small shareholders in our company, there should be a director to represent all these small shareholders. If the company feels like this, it can voluntarily, on a suo moto basis, can appoint a small shareholder director. This is the first scenario. Or if small shareholders gives a notice to the company asking the company to appoint a small shareholder director, in such a situation also small shareholder director can be appointed. Now, how many number of small shareholders have to give notice to the company? for the company to consider this. See, at least 1,000 small shareholders or 1/10 of the total small shareholders, whichever is lower, has to give notice to the company asking the company to appoint small shareholder director. In such a situation, company will consider the notice that has been given by the small shareholders. Okay, so how many small shareholders have to give the notice asking for small shareholder director? At least 1,000 small shareholders or 1/10 of the total number of small shareholders, whichever is lower. Okay, and the notice has to be given at the registered office of the company at least 14 days before the annual general meeting. Okay, at least 14 days notice proposing the small shareholder director has to be given at the company's registered address. Now in that notice, what has to be there? The name of proposed small shareholder director and the address of that small shareholder director, the contact details of such small shareholder director, shares if any held by the small shareholder director. Another question, whether it is mandatory for the small shareholder director to hold shares in the company. The answer is no. Okay, even if you are not holding any shares in the company, you can be appointed as a director, you can be appointed as a small shareholder director. Hope that is clear. So if in case that person is holding any shares in the company, you should also give the details of those shares in the notice that you give to the company. Next, DIN, director identification number of the small shareholder director. This is the basic requirement. Whatever the type of director you are going to be appointed, DIN is mandatory. Okay, director identification number. Next, consent from such a person. Declaration of non-disqualification. Under section 164, there are certain disqualifications. You should not get hit by those disqualifications. Okay, you need to give a declaration that I am not disqualified to be appointed as director under section 164. Next, comply with the requirements of independent director. For the purpose of independent director, there are various you know various points that needs to be satisfied by the person. Basically, section 149 subsection 4 to subsection 13, all those points needs to be satisfied by the person to be appointed as an independent director. Here you need to remember that small shareholder director will be treated as an independent director. Since he is treated as an independent director, small shareholder must satisfy all the requirements of an independent director as per section number 149 subsection 4 and subsection 13. Hope that is clear. Next, some additional points. The tenure of small shareholder director is 3 years. That means once you appoint a small shareholder director, he will hold the office for a period of 3 years. After 3 years gets completed, you cannot reappoint him again as a small shareholder director for another 3 years. That means the cooling period is 3 years. Okay, the tenure is 3 years, even the cooling period is also 3 years. No reappointment, cooling period is 3 years. Not liable to retire by rotation. I have already told you now, the tenure of small shareholder director is 3 years. So the concept of retirement of the director by rotation will not be applicable to small shareholder director. That is the reason why, while calculating the total number of directors in section number 152 subsection 6, from the total directors we have excluded small shareholder director, right? Next, one person can hold maximum 2 small shareholder director positions. That means, let's say I am a person, I can be appointed as a small shareholder in maximum of 2 companies only. Okay, the second company in which I am getting appointed as a small shareholder director should not be in a competitive business of the first company. Okay, the businesses of these 2 companies must be different. Only then I can be appointed in the as a small shareholder director in the second company. Hope that is clear. So the maximum number of small shareholder directorships that I can hold is only 2, and the second company should not be in the competing business. So that was section number 151, small shareholder director. Moving to section number 161, which is appointment of various types of directors. Here we will be discussing appointment of additional director, alternate director, nominee director, casual vacancy director. Okay, 4 types of directors we will be discussing here. First of all, section number 161 subsection 1, additional director. what is meant by additional director? Generally students will be confusing between additional director and alternate director. You need to be clear between these two types of directors. So first of all, understand the purpose of those directors. If you understand the purpose, there will not be any confusion. Additional director. Now, why additional director will be appointed? Let's say company is having 4 directors, Mr. A, Mr. B, Mr. C, Mr. D, and the work burden in the company is so heavy that these directors are not able to manage this work. They are feeling that there has to be another director in the company to share the work. Okay, so in this situation, to share the work burden, if you appoint another director, that another director will be known as additional director. Okay, so what is the purpose of additional director? Purpose of additional director is to share the work burden. Hope that is clear. And so section number 161 subsection 1 deals with additional director. This additional director can be appointed by any company. Okay, it is applicable to all the companies. Purpose to manage additional work burden. And by whom? Who can appoint these additional director? Generally, at the beginning of the class, section number 152 subsection 1, I have told you that director has to be appointed by shareholders at the general meeting. But there I have told you that I have told you certain exceptions. In some exceptional situations, the act has provided some different procedure. Additional director is one such scenario wherein additional director will be appointed by board of directors only. Okay, shareholders will not appoint the additional director. Board of directors is having power to appoint the additional director, and this power to board of directors has to be given by articles of association of the company. Okay, in the if in the articles of association of the company, the power has been given to the board of directors to appoint additional directors, then board of director can appoint additional director. Hope that is clear. See, additional director. To appoint additional director, AOA, that means articles of association, has to give power. Basically, just a second, let me put it this way. Additional director can be appointed by board of directors. From where this board of directors will get power to appoint additional directors? They will get power to appoint additional director from AOA. Okay, AOA has to give power to board of directors. If AOA doesn't give power to board of directors to appoint additional director, then the company cannot appoint additional director. Okay, board of directors cannot appoint additional director because AOA is silent. Okay, AOA has not given power to board of directors to appoint additional director. Okay, in such a situation, what you can do is, if AOA is silent, AOA has not given power to board of director to appoint additional director, but a company wants to appoint additional director. In this situation, what you will do? Simply, you can alter articles of association. How you can alter articles of association? By passing general meeting special resolution, you can alter articles of association to give power to board of director. Okay, first of all, AOA is not AOA has not given power to board of directors to appoint additional director. Okay, there is no point mentioned in AOA, but company wants to appoint additional director. In this situation, what you can do? You can alter AOA and you can insert this point in the AOA stating that board of directors can appoint additional director. To alter AOA, what you have to do? You have to pass general meeting special resolution. Okay, this is the route through which you can appoint additional director if AOA has not given a power. Okay, if AOA doesn't give the power, you have to first of all alter AOA, then By altering EOA, you have to give power to board of directors, then board of directors can appoint additional director. Hope that is clear. Next, tenure of this additional director. What will be the tenure of additional director? The tenure of additional director, obviously it will be till the next annual general meeting. Okay, in the upcoming annual general meeting he has to retire. And rejected director cannot be appointed as alternate director, sorry, additional director. See what happens here. Here board of directors can misuse this section number 161 subsection 1. To avoid such misutilization, Act has carefully inserted this point stating that rejected director cannot be appointed as a additional director. Why? See, board of directors wanted to appoint Mr. A as a director of the company. So what they can do? They have to make this proposal to the shareholders in the annual general meeting. In the annual general meeting, shareholders have rejected the proposal to appoint Mr. A. So Mr. A cannot be appointed as a director. But board of directors badly wanted to appoint Mr. A. In this situation, what the board of directors can do? They can go to section number 161 subsection 1 and appoint Mr. A as an additional director, right? Because board of director is having power to appoint additional director. They might not be having the power to appoint normal director, but they are having the power to appoint additional director. So there is a chance that board of directors might misutilize their power to appoint Mr. A as additional director. So to avoid this misutilization, section 161 subsection 1 says that rejected director or the rejected person cannot be appointed as additional director. Okay, once the shareholders rejects any person as a director, he cannot be appointed as an additional director. Okay, this is called as backdoor appointment. This kind of backdoor appointment cannot be made if the director, if the person is rejected by the shareholders in the AGM. Hope this is clear. Next, person already director or additional director cannot be appointed. See, simple point. If you are already a director in the company, okay, in the same company, there is A Limited. In the A Limited, you are a director. Already you are a director. Again, how you can be appointed as an additional director? Okay, is there any sense of being appointed in the same company as an additional director? No. So, if you are already a director in the company, in the same company, you cannot be appointed as an additional director. Hope that is clear. So that was additional director, section number 161 subsection 1. Moving to alternate director, section number 161 subsection 2. What is this alternate director? See, alternate, the term itself represents that this person is being appointed as a alternate to some other person. That is the reason why you are calling him as alternate director. So alternate to whom? Okay, alternate to whom you are appointing this person? Let me tell you. Let's say there is a director and there is a vacancy in the position of such director. Okay, let's say Mr. A. Mr. A has went on a leave. Okay, he has kept leave in the company. And if the director, see, director is on leave, if the period of leave is less than 3 months, see, period of leave is less than 3 months, in such a situation no action need to be taken. If the period of leave is more than or equal to 3 months but less than 12 months, okay, if the period of leave of the director is less than 3 months, then no action is required. If the period of leave is 3 or more months but less than 12 months, and during that leave period such director is staying within India only, see, in that leave period such director is staying within India only, in such a situation also no action taken. But if in that leave period that director goes abroad, okay, director outside India, in such a situation, as a alternate to such a director, you can appoint some other person as a alternate director. See, board may appoint alternate director in such a situation. So in which situation the alternate director will be appointed? If the actual director is on leave for more than or equal to 3 months, and during that leave period he is not there in India, he is abroad, in such a situation, as a alternate to such a type of director, you can appoint alternate director. Okay. Next, if the director is on leave for more than 12 months, in such a situation, casual vacancy will be created in his place. Casual vacancy. Why casual vacancy will be created? Basically, if you see in chapter number 3, meetings of board and its powers, it says that director must at least director must attend at least one board meeting in a period of 12 months. Okay, if he doesn't attend at least one board meeting in a period of 12 months, it will be deemed that he has vacated his office. So here, if he is in leave for more than 12 months, it is obvious that he has not attended any board meeting in that period. If he has not attended any board meeting, it will create a casual vacancy of his office. I will explain what is meant by casual vacancy. Section number 161 subsection 4. Okay, that section I'll explain after completing this section. We are having nominee director. After nominee director, I'll explain casual vacancy. So if director is on leave for more than 12 months, then casual vacancy will be created in his office. You just remember this point as of now. Okay. And this I have already told you. The same thing here also, just like additional director, the alternate director can be appointed by board of directors, and to appoint such a alternate director, board of directors must get that power from the articles of the association. Okay. And some additional points. Tenure of the alternate director. What will be the tenure of alternate director? See, the tenure will be the tenure of actual director, or the date on which the actual director returns to India, whichever is earlier, that will be the tenure of the alternate director. Okay. Original director's tenure or original director return to India, whichever happens first, that will be the tenure of alternate director, because alternate director has been appointed as an alternate to original director. So the tenure of alternate director will be the tenure of the original director, or the date on which original director returns to India, because once original director returns to India, his position will be taken over by him and alternate director has to retire. Okay, so that is tenure of alternate director. Next, alternate director for independent director. See, if you wanted to appoint a alternate director for an independent director, then see, whenever the term independent director comes, you should remember that independent director, to call a person as an independent director, he needs to satisfy various conditions of section 149 subsection 4 to subsection 12. So if you are appointing a person as an alternate to the independent director, that person whom you are appointing as an alternate director should also satisfy all the conditions of section number 149 subsection 4 to subsection 13. Hope that is clear. Why? Because he is being appointed as an alternate to the independent director. Okay. Next, removed or rejected director can be appointed as a alternate director. There is a no bar on this. That was section number 161 subsection 2, alternate director. I guess you are clear with the difference between alternate director and additional director. Now moving to nominee director. I have already told you the concept of nominee director. Nominee director will be appointed in the company on behalf of some external organization. The reasons could be various reasons. One of the most popular reason is that the external organization might have given loan to the company, so the external organization wanted to know what is happening in the company. So for that purpose, representing that external organization like a bank or financial institution, it will appoint a person as a director in the company. Since he is representing, he is nominated by that external organization, he will be known as nominee director. See, appointed on behalf of external organization, financial institutions, central government or state government. In some situations, if state government or central government has invested some amount in your company, in then also state government representatives will be appointed as a director in your board of directors. In such situation also they will be called as nominee director, okay, because they are nominated by central government or state government. Next, nominee director will be appointed by board of directors. Basically that external organization or the state government or central government will tell board of directors that they wanted to appoint so and so person as nominee director, and board of directors will appoint that particular person as nominee director in their company, okay, and tenure will be till removal by such organization. That is simple. So this is about nominee director. Next, casual vacancy director. Section 161 subsection 4, casual vacancy director. Now, in order to call a particular vacancy as a casual vacancy, there needs to be two conditions that has to be satisfied. What are those two conditions? The first condition is that he has to be appointed by shareholders in the annual general meeting, and the office is vacated before expiry of the term. If these two conditions are satisfied, only then you can call that particular vacancy as a casual vacancy, okay. So what are the conditions that needs to be satisfied? First of all, the director who has vacated should have been appointed in the annual general meeting by the shareholders, and the director has vacated his office before the expiry of his term. If these two are satisfied, then you can call it as casual vacancy. Now, why we are discussing about this casual vacancy? Because the casual vacancy can be filled by board of directors, okay. You need not wait for the shareholders to fill the casual vacancy. If any casual vacancy is created in the company, that casual vacancy can be refilled by the board of directors themselves. So what is the time period within which casual vacancy has to be filled? First of all, this casual vacancy will be filled by board of directors by passing board meeting ordinary resolution, and however this has to be subsequently approved by the shareholders in the upcoming annual general meeting, okay. Appointment will however be made by board of directors, okay. The casual vacancy will however be filled by board of directors, but such fulfillment or such appointment made by the board of directors has to be subsequently later on in the upcoming general meeting. Shareholders have to approve that, okay. And tenure will be till the expiry of tenure of the original director. That will be the tenure of the casual vacancy director. Now, if you wanted to fill casual vacancy of women director and or the independent director, there are certain timelines that has been prescribed, okay. The casual vacancy of women director and the casual vacancy of the independent director has to be filled within 3 months from the date of vacancy or by the next board meeting, whichever is later, okay. Within that period you need to fill the casual vacancy of independent director and the women director. Whereas in case of other directors, there is no such urgency, okay, no such timelines prescribed for filling the vacancy of other directors. But vacancy of women director and independent director has to be has to be filled within those prescribed timelines. That was section number 161 subsection 4, filling of casual vacancy. By this we have completed entire section number 161. Moving to section number 160. What is this? Section number 160. Basically, section number 160 is all about appointing a person other than a retiring director as a uh, director. Let's say, for example, Reliance Industries. Now, in the Reliance Industries, I wanted to get appointed as a director, whether there is such a possibility, or you wanted to be appointed as a director of Reliance Industries. Okay, you are having a dream that you wanted to act as director of Reliance Industries, whether it is possible. The answer is yes, as per section number 160. If you wanted to be appointed as director of any company, what you can do is you can follow 160. What section number 160 says? Let's see. First of all, to appoint any person as a director, either board of director will recommend any person as a director to the company. Okay, the final appointment will be made by shareholders only, but the recommendation that this person is so good, this person can be appointed as a director, such type of recommendation can be made either by board of directors or by shareholders, or the person he himself can approach the company and tell the company that I wanted to get appointed as a director of your company. So what is the procedure that I have to follow? So these are the three ways of identifying a person as a director. Now, if board of directors recommend a person as a director, then there will not be much procedure. Okay, section 160 you need not apply, but because board of directors, they would have already you know they would have already done all the background work, and if they feel confident that this person is so much necessary for our company, only then they will recommend that person as a director, right? So if recommendation has come from board of directors, you need not go through all these procedure of section 160. But if the recommendation has come from shareholders to appoint a person as a director, or the recommendation has come from a uh, sorry, the person he himself has approached the company to to appoint him as a director, in such situation what has to be done is, first of all, the candidature or the proposal for appointment has to be given to the company at least 14 days before the general meeting. Okay, the final appointment will be made by shareholders only, right? So where the shareholders will take the decision in annual general meeting, shareholders will take the decision. So the candidature or the proposal has to be submitted to the company at its registered office at least 14 days before the general meeting. What should be there in this candidature? The name of the person, the qualifications of this person, the contact details of this person. So all these, and why that person has to be appointed as director. Okay, so all these details has to be there in the candidature or proposal, and it has to be sent to the company within 14 days before the annual general meeting. Along with that candidature, a deposit of 1 lakh rupees should also be made with the company. See here, in order to test the seriousness of that person, a deposit of 1 lakh rupee has been kept. If you are willing to be appointed, okay, if you wanted yourself to be appointed as a director of some Reliance Industries, you can't just like that, you can't just like that go and give your candidature. Along with candidature, you have to deposit 1 lakh rupees with the Reliance Industries, because if just a candidature is enough, tomorrow lakhs of applications will go to the Reliance Industries asking to appoint them as a director. So to test the seriousness of the person, a deposit of 1 lakh rupee is also kept. Okay, see this 1 lakh rupee, it will not be refunded to you. If you fail to get appointed as a director, it will be forfeited by the company. Okay, they will not refund to you. There are some exceptional situations in which the amount will be refunded. I'll tell you those exceptional situations. So basically, along with your candidature, you should also deposit 1 lakh rupees with the company. If in case that company is a Nidhi company, then deposit is just 10,000, not 1 lakh rupees. Except Nidhi company, for all other companies, the amount that you have to deposit is 1 lakh rupees. After company receives this proposal and 1 lakh rupees, what the company has to do is, company sorry, at least 7 days before annual general meeting, it has to circulate this candidature to all the shareholders, because the decision has to be taken by shareholders only in the general meeting. So company has to inform to the shareholders that, see shareholders, we have received this proposal from this person uh, to appoint him as a director. You please check his details and give your decision in the annual general meeting. So to take this decision, at least some time has to be given to the shareholders so this candidature has to be circulated by the company to the shareholders at least 7 days before the general meeting. Along with that, see, forward candidature to members individually, either through email or through post. Along with that, you should also advertise, who the company has to advertise the candidature of this person in a newspaper, basically in at least one vernacular newspaper. You need to advertise. Vernacular newspaper means the local language. Okay, let's say the company is incorporated in Andhra Pradesh, then in at least one Telugu newspaper along with one English newspaper you need to advertise. Okay, if you advertise in the newspaper the candidature of the person, in that situation you need not individually send this candidature to all the shareholders, because you have advertised it in the newspaper itself. So individual circulation is not necessary. And also you need to place the candidature or the proposal of this person on the website of the company. Okay, company has to place his candidature on the website of the company at least 7 days before the annual general meeting. Hope that is clear. So after doing all this, in the general meeting, shareholders, they will decide whether to appoint this person as a director or not. Now what about that 1 lakh rupees deposit, whether that 1 lakh rupee deposit will be refunded to this person or not? Let's see the scenarios. Refund of deposit. If that person gets appointed as a director, okay, if the shareholders approve appointment of such a person as a director, in such a situation that 1 lakh rupee will be refunded to such person because he has got appointed as a director. Next, if he has not got appointed as a director, but the votes in favor of his appointment are more than 25%. Okay, he has secured votes of more than 25%, but he has not got appointed, because to get appointed you need to secure more than 50% of voting. But your voting is less than 50% but more than 25%. In such a situation also your 1 lakh rupee will be refunded. If your voting is less than 25%, in such a situation your entire 1 lakh rupee will be forfeited by the company. Okay, if in case that company is a section 8 company, in such a situation the directors of section 8 company, they can decide whether to refund the amount or not to refund the amount. Okay, in case of section 8 company the decision is left to the board of directors itself, but in case of all other companies they can forfeit your amount if you don't get appointed and the votes that you secured are less than 25%. Hope that is clear. And this section number 160, it is not applicable to government companies, private companies, section 8 companies. Hope that is clear. That was section number 160. Now moving to section number 165, which is about maximum number of directorships. Now see, director means, why you are being appointed as a director? To do work, right? You'll not simply sit, you have to take decisions, you have to manage the business. So if you get yourself appointed as a director in lot of companies, you will not have sufficient time to properly engage with all the companies. So what the act has done is it has put a limit on the maximum number of directorships a person can hold. The limit is 20 directorships. Okay, a person can hold maximum of 20 directorships. He cannot hold more than 20 directorships. The two, in this 20 directorships, the maximum number of public companies in which he can act as a director is 10 only. Okay, the broad all the companies limit is 20. In that 20 also public companies 10 only. Okay, in that 20 maximum of public companies for which you can get appointed as director is 10 only. Hope that is clear. And another point that you need to remember is public company includes private companies which are subsidiaries of the public companies. Okay, if you are appointed as a director of a private company and that private company is subsidiary of some other public company, in such a situation that private company will also be treated as a public company for the purpose of section 165. Okay, and for calculating this maximum of 20 directorships, you can exclude your directorships in dormant company and section 8 companies. Okay, the directorships that you are holding in dormant company means the company is not doing any significant business. Okay, and section 8 companies, if you are acting as director of dormant company or any section 8 company, those directorships you can exclude for calculating this maximum of 20 directorships. You should include alternate directorship for calculating 20 directorships. Okay, if you are acting as alternate director in any company, even that has to be included for calculating this 20 directorships. And a lesser limit can be prescribed by general meeting special resolution. Let's say if any company, there is a limited, a limited in its articles, it has reduced the maximum number of directorships of its directors as 10 only. That means whoever gets appointed as a director of a limited, that person can hold maximum of 10 directorships only. Like this, this is a rule of a limited. In such a situation, the AOA of a limited will get will be applied for that person who has got appointed as director of a limited. Okay, so lesser limit can be prescribed by passing general meeting special resolution. I hope that is with respect to section number 165. Now moving to section number 164, which is disqualification of director, right? Let me try if I can rotate it. No. Okay, just a second. I guess I'm not able to rotate this. Okay, let it be. Okay, let's see this. So section number 164, disqualification of director. Please adjust with this. I'm not able to rotate this actually. So disqualification of director. Section number 164, it is having two subsections. Section number 164 subsection 1 and subsection 2. Subsection 1 basically deals with individual default disqualifications. Subsection 2 deals with company default disqualifications. See, the difference is in subsection 1, if the person hits by any disqualifications, then he cannot be appointed as director. Whereas subsection 2 is, if the company in which the person is acting as a director gets hit by any disqualification, then that person will be disqualified. Okay, so subsection 1 is individual default disqualifications, subsection 2 is company default disqualifications. Hope you got the difference. So there are 9 individual default disqualifications. If a person possesses any of these disqualifications, then he cannot be appointed as a director. What are those disqualifications? First of all, he is of unsound mind. If he is an unsound mind, he cannot take proper decisions, so he is disqualified to be appointed as a director. Next, he is undischarged insolvent. First of all, what is meant by insolvent? If your liabilities are more than your assets, then it will be said that you are insolvent. See, basically the situation is, Mr. A we will be discussing this similar concept in IBC also, insolvency bankruptcy code. In the economic class, we will be discussing this insolvency bankruptcy code. Now, Mr. A, Mr. A is having liabilities of some 10 crore rupees, whereas his assets are just 1 crore rupees. So with the assets that he is having, he is not able to repay his liabilities. So what he will do? He will file for insolvency petition with the court, right? Insolvency petition, asking the court to discharge him from all these liabilities. Okay, he is not able to repay the liabilities, so please discharge me from these liabilities. He will file an insolvency petition, okay, IP you will call it, with the court. Now here, let's say there will be certain 3 scenarios here. The person has filed the petition, okay, filed insolvency petition with the court, and still the court has not accepted the insolvency petition. Okay, after filing the insolvency petition, after some 1 month or 2 months, court will accept the insolvency petition. After accepting the insolvency petition, court will not immediately discharge him. It will take another 1 or 2 months to discharge him from all his liabilities. Okay, let's say again after 2 months it has discharged him from all the liabilities. Basically, court will give a order stating that this person, uh, he he has been declared as insolvent. With his assets, he is not able to clear his liabilities, so whatever the amount has been, whatever the amount we have got from his assets, we will be distributing it to all the creditors, and from that date onwards, he is not liable to anyone. He will start his life afresh. Like this, a order will be given by the court, so that is known as discharge order. Okay, from what he has been discharged, from the liabilities he has been discharged. These are the 3 stages that are involved. Now the question is, from which stage he will be disqualified to be appointed as a director? Okay, by the time he files a petition, will he get disappointed, will he get disqualified as a director, or after court accepts his petition he will get disqualified as a director? Let's, basically there are 3 points. First of all, the second point here is undischarged insolvent. Okay, if he is a undischarged insolvent, okay, court has not yet discharged him from the insolvency, in this situation he will be disqualified to be appointed as a director. Next, applied to be adjudged as insolvent and application is still pending with the court, in this situation also he will be disqualified to be appointed as a director. Okay, that means once he files a application to the court, once he files a insolvency petition to the court, from that stage he will be disqualified to be appointed as a director. Okay, that is the third point. Next, fourth, convicted by court and imprisonment of less than 6 months. Let's say he has committed any crime and court has convicted him as a criminal, and court has given him a punishment with imprisonment of less than 6 months. If the punishment is less than 6 months, then he is qualified to be appointed as director. Okay, if the imprisonment is less than 6 months, then he is not disqualified, he can be appointed as a director. But if the imprisonment is more than 6 months but less than 7 years, in such a situation he will be disqualified to be appointed as a director for a period of 5 years from the date on which his sentence expires. Okay, his imprisonment sentence expires, from that date for next 5 years he cannot be appointed as a director if the imprisonment is for more than 6 months but less than 7 years. If the imprisonment is for more than 7 years, in such a situation lifelong he is disqualified to be appointed as a director. Okay, lifetime disqualification if imprisonment is 7 years or more. Hope that is clear. That is the fourth disqualification. Next, fifth disqualification, court itself gives a order stating that this person is disqualified to be appointed as a director, in that situation also he is disqualified. Next, failed to pay calls on shares for 6 months. Basically, some companies they will collect money on shares in the form of calls, right? Call 1, call 2, application money, like this they will collect the shares amount. If company has made the call and the person has not paid the call amount for a period of 6 months, in such a situation he will be disqualified to be appointed as a director because he failed to pay the call money. Next, convicted under section 188. What is section 188? We will be discussing section number 188 in third chapter. Basically it deals with related party transactions. There are certain disclosures that has to be made, and if director doesn't follow section number 188, that is related party related terms and condition, there are certain penalties that will be imposed on the director. Okay, so if the person contravenes section 188, then he will be disqualified to be appointed as a director. This section number 188 we will discuss in detail in the third chapter. Okay, as of now you just remember that if he contravenes section number 188, he will be disqualified to be appointed as a director. Next, if the person is not having a DIN, director identification number, I have told you now DIN is mandatory. Without DIN you cannot appoint, you cannot get yourself appointed as a director. So if you don't have a DIN, you are again disqualified to be appointed as a director. Next, exceeded maximum directorships under section 165. I have told you now a person can be appointed as a director in maximum of 20 companies only. In the 20 also maximum public companies can be only 10. If the person has exceeded that maximum limit, again he will become disqualified to be appointed as director in the additional companies, right? So these are the 9 individual default disqualifications. Now moving to company default disqualifications. See, company default disqualifications means the company has committed a default. Because of that, the person who is acting as a director of that company will become disqualified. Okay, the action that the company has done will impact its directors. See, company default disqualifications. Basically, there are two defaults that the company might commit. One, company failed to file financial statements or annual return for 3 continuous financial years. Basically, company for every financial year it needs to prepare financial statements and submit them to the MCA, Ministry of Corporate Affairs. Along with financial statements, it should also furnish annual return, right? AOC 4 and MGT 7. So if company fails to furnish these forms for a continuous period of 3 financial years, then the persons who are acting as a directors in such a type of company will hit with this disqualification. They cannot be appointed as director of any other company for a period of 5 years. Next, another default: failed to repay deposits, debentures, interest, declared dividend for a period of 1 year. See, if the company has accepted any deposits from the public, if the company has issued any debentures to the public, or if the company has declared any dividend and failed to repay those deposits, failed to redeem those debentures, failed to pay the declared dividend, failed to pay the interest on the debentures, failed to pay the interest on the deposits, in all these situations, the company for a period of 1 year, okay, if such a failure continues for a period of 1 year, in such a situation, again the person who is the persons who are acting as directors of such a company will get disqualified from getting appointed as director in other company for a period of 5 years. And in the same company they can continue as a director, but they cannot be reappointed. Okay, see, in case of company default disqualifications, in that company in which they are acting as a director, they can continue as a director till their tenure completes, but they cannot be reappointed in that company. And in all other companies, they will be disqualified for a period of 5 years. Okay, in the existing company they can continue till their tenure continues, till their tenure expires, but for the purpose of all other companies they will be disqualified. Hope that is clear. See, the same I have given here: disqualified from reappointment in the defaulting company. Okay, in the defaulting company they can continue, but they are disqualified for reappointment in the defaulting company and appointment in other companies for a period of 5 years. Another point: let's say company has committed this default. Let's say it has not filed its financial statements or annual return for a period of 3 years. So company has committed the default. The existing directors of that company, they will get hit by the disqualification. Let's say in this type of company which has already committed the default, a new person gets appointed as a director. In such a situation, this new person will not immediately gets hit by the disqualification. A period of 6 months has been given to this new person. Okay, after completion of 6 months, this person will get hit by the disqualification, because the reason is the new person, without knowing that the company has committed a default, he might be appointed as a director. Okay, without knowledge he might get himself appointed as a director. So a period of 6 months has been given to that person, because in that period of 6 months he would be involving in the company, he would be seeing various documents related to the company. So in that 6 months he needs to make sure, or he needs to identify whether the company is whether the company has committed any of these defaults or not. If in these 6 months period also he has not identified, means he will get disqualified from getting appointed as a director for a period of 5 years in other companies. Okay, so here you need to remember that the newly appointed director will not get immediately hit by the disqualification. A period of 6 months, a lag period of 6 months has been given for the newly appointed director. Okay, the reason is he might be appointed without knowing. The act is expecting that he has to identify the default in a period of 6 months. If he doesn't identifies, he also will get hit by the disqualification. Next, apart from these disqualifications that we have discussed, if the companies in their articles of association, if they wanted to add additional disqualification points, they can happily add. Okay, private companies can provide for additional disqualifications in the articles of association. Hope that is clear. So this is section number 164, which is related to disqualification of directors. Now moving to section number 167. So if you see section number 167, it deals with vacation of office of director. What is the difference between section number 164 and section number 167? Let me explain you. Section number 164 deals with disqualification of directors, right? Section number 167, right? Yeah, it deals with vacation of office of director. Now you need to check whether director or whether the person that you are going to appoint is disqualified at the time of appointment. Okay, you need to check whether the person is disqualified at the time of appointment and also after he has got appointed. Okay, so the person should not be disqualified at the time of appointment and even after getting appointed, right? You will check this section 164 disqualification at the two times, whereas section 167 vacation of office is there na, you need to check the points that are given in vacation of office after the director is appointed. Okay, at the time of appointment you need not check those points. See, in order to vacate the office, first of all he has to be appointed as director, right? Only if he is appointed as a director he can vacate the office. Without being appointed, how can he vacate? So here, after appointing, if the director gets hit by section 164 disqualifications, then also he has to vacate the office. The first point under section 167 is that only director will vacate the office if he gets hit by disqualifications under section 164. Okay, so the difference is you will check 164 points at the time of appointment and after appointment, whereas you will check 167 points only after appointing, only after appointment. Okay, now we'll see the various situations in which a director has to vacate his office. The first point, as I have already told you, if he gets hit by disqualifications under section 164, he has to vacate his office. That is the first point or first situation in which the director will vacate his office. Next, even this point I have told you already. If he absents from all board meetings in the past 12 months, okay, if he absents from all the board meetings in past 12 months, then also he has to vacate his office. This point I have told you while discussing alternate director, right? While discussing section number 161 subsection 2, I have told you this point, right? If director is on leave for more than 12 months, then casual vacancy will be created, right? So this is the second situation in which director has to vacate his office. Next, contravenes section 184, fails to disclose interest under section 184. Basically section 184, it deals with disclosure of certain interests that the director is having. If he fails to disclose those interests, if he fails to comply with section number 184, we will be discussing section 184 in third chapter, meetings of board and its powers. So if you contravene section 164, then also the person will be the director has to vacate his office. Next, Disqualification by order of court or tribunal, this point we have already discussed in section 164. Okay, if the director is disqualified by order passed by a court or tribunal, then he has to vacate his office. Next, convicted of an offense and imprisonment for 6 months or more, even this point we have discussed in section number 164, right? If he is convicted by a court and an imprisonment of 6 months or more has been given, then he has to vacate his office. Next, disqualification under section 217 subsection 6. Basically 217 subsection 6, this section comes in the chapter operation and mismanagement. Okay, operation, just a second, yeah, operation and mismanagement. In this chapter section 217 subsection 6 will come. Basically there, operation and mismanagement, they are completely different concepts. We will be discussing them in fifth chapter. Okay, so there tribunal will pass an order against the director if it is proven that they have conducted operation or mismanagement in the company. Okay, so if the director is disqualified by an order passed by tribunal under section 217 subsection 6, then also the director has to vacate his office. Next, appointed as director by virtue of him holding other office. See, in some situations what will happen is, in the articles of the company or as per the convention of the company, let's say A Limited will always appoint the CEO, or let's say basically, let's say central government has invested a certain amount in A Limited. Since the central government has invested certain amount in A Limited, the finance minister from central government will be appointed as director of A Limited. Now, if you see here, you are not appointing a particular person directly as a director. Okay, you are appointing a person holding certain position as a director. Now, as on today, finance minister is Nirmala Sitharaman. So you have appointed Nirmala Sitharaman as director. Why? Because she is the finance minister. Now let's say after 1 month or 2 months, some other person, Mr. X, has become finance minister. Okay, so Nirmala Sitharaman has been removed as a finance minister and Mr. X has been appointed as finance minister. Now what the company will do? Company will also remove Nirmala Sitharaman as director and it will appoint Mr. X as director, right? So here Nirmala Sitharaman is vacating her office. Why? Because she has been vacated from the post of finance minister. So that is the last point. You can read it once again. Let's erase this. Yeah. Appointed as director by virtue of him holding other office. In this situation, if he vacates his position of other office, he should also vacate his office of directorship. Okay, so these are the 7 scenarios or 7 situations in which a director will have to vacate his office. Now, a special scenario, what, let's say the company is having 4 directors. If all these 4 directors got hit by these points, any of these points, and 4 directors at the same time vacated their office. Now in this situation there are no director in the company. How to deal with situation? See, note, if all directors vacate, in such situation either promoters, if the company is not having promoters, in their absence central government will appoint the directors. Okay, if all the directors have vacated at the same time, then from either promoters of the company will appoint the new directors, or if promoters are not there, then central government will appoint the new directors to the company, and these new directors shall hold office till directors are appointed by shareholders in the general meeting. Okay, these new directors, they will hold the office till new directors are appointed by shareholders in the general meeting. Basically, if you see this type of scenario, it has happened in case of Satyam. Okay, in many companies this has happened. At the time where when the Satyam scam took place, all the directors have vacated. Okay, then central government has come. If you see there, promoters are also not there. In fact, promoters are the one who are involved in the fraud, so promoters are also not there. Then central government has come and it has appointed directors to Satyam. Okay, they have held their office in Satyam around for 180 days or so. So that was section number 167, vacation of office of director. Now moving to section number 168, resignation of director. Now if you see, till now we have seen appointment of director, disqualification of director, vacation of office of director, now resignation of directors. Okay, director has been appointed to the company. After appointing, after some days, director is unwilling to continue in the company. Now in this situation, whether he is having an option to submit his resignation, the answer is yes, he can submit his resignation as per section 168. Let's see what section 168 is saying. Director, he can give notice to whom? To the company, that he wants to resign as a director of the company. And once a company receives this notice from the director, within 30 days company has to file dir 12 with register of company, stating that this particular director has resigned from our company. And also director should also within 30 days of resignation file dir 11 with the company, stating that I have resigned from this company. So within 30 days company has to file dir 12, director has to file dir 11. Hope that is clear now. Okay, director, he will give notice of resignation to the company. Now here the question is, after director gives notice of resignation to the company, from which date director will be deemed to be vacated? Here the answer is, see, effective date of resignation, it will be later of date of receipt of notice by the company, or date specified in notice, whichever is later, that would be the effective date of resignation. Let me tell you now. On 1st April 2024, director has wrote a letter of resignation. Okay, he wrote a letter of resignation. Now in this letter of resignation, he mentioned that he will resign, his resignation will be effective from the date from 5th May 2024. Okay, he has mentioned that his resignation will be effective from 5th May 2024, and on 1st April 2024 only he has posted this resignation to company. Okay, and company has received this resignation letter of director on, let's say, some mm, Company has received resignation letter on okay 15th April 2024. So on this date company has received resignation letter. Now from which date the resignation will be effective, whether from 15th April 2024 or 5th May 2024? The answer is later of these two dates, which is 5th May 2024. Okay, so from this date resignation will be effective. Let's say for example, in the resignation letter, director has mentioned that his resignation will be effective from 1st April itself. From 1st April 2024 his resignation will be effective, like this he mentioned. But that resignation letter reached company on 15th April 2024. In this situation, later of these two dates, that is from 15th April, the resignation will be effective. Hope that is clear. So that was section number 168, which is resignation of director. Moving to section number 169, which is removal of directors. Okay, in section 168, director he himself given the resignation letter, whereas in section 169 shareholders want to remove the director. In that situation, shareholders can remove the director by passing general meeting ordinary resolution. See, for appointing director, general meeting ordinary resolution is required. So for removal of director also, general meeting ordinary resolution is only sufficient. Simple. But along with it, a special notice under section 115 has to be given. What is the special notice? I'll explain you. Basically, you should have known about this special notice at your CA intermediate level itself, because section number 115 it has been covered in inter syllabus. I'll also explain it, don't worry. So section number 169, removal of directors. Director can be removed either by shareholders or by tribunal on application under section 241. 241 is application of mismanagement. Okay, so if shareholders file an application with the tribunal stating that our directors are not properly managing the business of the company, they are doing mismanagement, in such situation tribunal can pass an order of removal of the director. That is section 241. I have just given a crisp of section 241. In chapter number 5 we will be discussing this section 241. Okay, so if shareholders want to remove the director, how they can remove? Just by passing general meeting ordinary resolution, they can remove the director. And also along with general meeting ordinary resolution, 14 days special notice under section 115 has to be given by the shareholders. See, shareholders they wanted to remove the director. If they want to remove the director, at least 14 days before the annual general meeting, they have to give a special notice to the company stating that they wanted to remove so and so director. Now, what is meant by a special notice? Special notice means such a notice which is signed by members holding not less than 1% voting rights, or members holding shares on which at least 5 lakh rupees has been paid up. Okay, in order to call a particular notice as a special notice, it should be signed by members holding at least 1% of the voting rights, or by members holding shares of face value of at least 5 lakh rupees. Okay, in such a situation that notice will be called as a special notice. So to remove a director, special notice from the shareholders has to be given at least 14 days before the annual general meeting, and in the annual general meeting ordinary resolution has to be passed for removal of the director. However, there are exceptions for this. Shareholders can remove all the directors except certain types of directors. Okay, shareholders cannot remove certain types of directors by this procedure. Who are those directors? First one, if the director is appointed by tribunal under section 242, Okay, this 242, it also comes in chapter number 5. If the tribunal itself has appointed a director to the company, in such situation, shareholders will not have power to remove such director. Okay, since the director is appointed by tribunal, only tribunal can remove such director. Hope that is clear. So the director appointed by tribunal cannot be removed by the shareholders. Next, proportional representation director under section 163. I have told you now, under section 163, the special method for appointing the director, which is a proportional representation method of appointing the directors. If the director has been appointed by this method, then also shareholders cannot remove such director. Another important point, second time appointed independent director can be removed by passing general meeting special resolution. Okay, in order to remove an independent director who has been appointed for the second time in the company, then general meeting special resolution is required. Okay, this point we will be discussing in section 149, that is in independent director concept. We will be discussing that point. You need not worry about that. Okay. Yes. So by this we have completed section number 169. Almost all the sections are completed except independent directors concept. Now we will discuss independent directors. Yeah. So independent directors, section number 149, subsection 4 to subsection 12. Okay, these subsections, they deal with independent directors. Now first of all, we will see applicability of independent directors. To which companies independent directors are mandatory? First of all, for listed companies, if a company is a listed company, then for such company independent directors are mandatory. How many directors must be independent? One third of the total directors must be independent directors. Okay, in case of a listed company, one third of the total directors must be independent. Now first of all, before going into that applicability, what is meant by independent director? Independent director, now the name itself suggests that he is not dependent. Okay, basically the company will be having various types of directors, like managing director, whole time director, right? So if you see managing director, whole time director, they are employees of the company. If they are employees of the company, means they are dependent on the company. Okay, they are having some interest in the company, some sort of interest. And various other types of directors also, they are not independent until and unless they qualify all the criteria prescribed in section number 149. Now the purpose of these independent director is, in the company various business decisions will be taken, right, by board of directors. Now here in the board of directors, there is a possibility that directors might take decisions which benefit for themselves, right? In order to avoid those types of situations, there should be independent directors in the board of directors. Okay, if there are independent directors, independent means they will not act or they will not take decisions that will benefit for themselves. Okay, they will always think in favor of company, right? So those are, they are independent directors. Now to think in the benefit of company, certain qualifications has certain criteria has to be fulfilled. Okay, if those criteria are fulfilled, then it will be deemed that this person will not take decisions that will benefit himself, that will benefit him. Okay, he will take decisions, that will benefit only the company. So those types of directors will be known as independent director. In order to call a particular person as independent director, we will see the criteria. Basically, the purpose of having independent director is to avoid frauds on the company. Okay, to take proper decisions in the company. Okay, to take decisions that are more beneficial to the company instead of the decisions that are beneficial to the directors themselves. Okay, so applicability of this independent director concept for all the listed companies, 1/3 of its total directors must be independent directors. Let's say company is having total 9 directors. Of these 9 directors, 1/3, that means 3 directors must be independent director. Okay, and in case of other public companies which are having paid up share capital of 10 crore or more, turnover of 100 crore or more, borrowings of 50 crore or more. Okay, other public companies whose turnover is 100 crore or more, or paid up share capital is 10 crore or more, or borrowings is 50 crore or more, if any of these condition is satisfied, then such a public company should also appoint independent director. But the number of independent director that such public company should appoint is at least 2 independent director. Okay, here the 1/3 requirement is not there for such other public companies. Just 2 independent directors must be there if these conditions are fulfilled by any public company. Okay, if the public company doesn't fulfill any of these criteria, then it need not appoint any independent director. And also private companies also need not appoint any independent director. Okay, for private companies the concept of independent director is not applicable. Okay, so this independent director concept is applicable only for listed companies and public companies satisfying this criteria. Next, exempted unlisted public companies. Okay, there are certain public companies, even if they fulfill this criteria, they need not appoint independent director. What are they? Joint venture companies. Okay, a joint venture public company, if it is fulfilling any of these criteria, then it need not appoint independent director because it is exempted from appointing independent director. Next, wholly owned subsidiary company. Okay, a wholly owned subsidiary company, if it is satisfying any of these criteria, it need not appoint independent director. Next, dormant company under section 455, even a dormant company need not appoint independent director. Okay, these are the companies that are exempted from appointing independent directors. Next, eligibility to be appointed as an independent director. Okay, the person whom you are going to appoint as an independent director must possess certain qualifications. Okay, you have to appoint only such a person who is having such qualifications as independent director. Okay, you cannot appoint a random person as an independent director. Okay, he must possess certain qualifications. What are they? First of all, such a person should not be managing director, whole-time director, nominee director. Okay, the person whom you are going to appoint as independent director should not be managing director of the company, should not be whole-time director of the company, should not be nominee director of the company. Why? See, managing director and whole-time director, they will be treated as employees of the company. If they are employees of the company, how can they act independent of the company? Right, they are dependent on the company, so they will not become independent directors. Next, nominee director. Nominee director means some external organization would have appointed such nominee director. So here nominee director is also dependent on such external organization, so he also cannot be treated as an independent director. Hope that is clear. So independent director should not be a managing director, whole-time director, or nominee director of this company. Next, so you cannot consider these directors as independent directors. That is what the section want to say. That is the first qualification. Next, possess relevant expertise and integrity. Okay, the independent director should have relevant expertise to take the decisions, and he should be having integrity. Integrity means straightforwardness, okay, truthfulness. That is a second qualification. Next, third qualification, person who is or was not promoter of the company, holding company, subsidiary company, associate company. Okay, the person whom you are going to appoint as a independent director should not be promoter of your company, should not be promoter of your company's holding company, should not be promoter of your company's subsidiary company, should not be promoter of your company's associate company. Okay, holding company means the company which has invested in your company. Okay, the company which is holding 50% or more shareholding of your company. Subsidiary company means the company in which you are holding 50% or more, right? And associate company means the company in which you have invested 20% or more. Just a second. Yeah, so the company in which you have invested 20% or more will be your associate company. So the promoter of these companies should not be appointed as independent director. And also, person who is or was not related to promoter or director of company, holding company, subsidiary company, associate company. Okay, the person whom you are going to appoint as an independent director should not be relative of promoter or director of this company, holding company, subsidiary company, associate company of your company, right? Hope you understood this. So you can easily understand this point by just going through this chart. Next, fourth point, person should not have or had any pecuniary relationship. Pecuniary relationship means relationship in terms of money, right? So the person whom you are going to appoint as an independent director should not have any pecuniary relationship with whom? With promoter or director of holding company, with promoter or director of your company, with promoter or director of your company's subsidiary company, with promoter or director of your company's associate company. Okay, the person whom you are going to appoint as an independent director should not have or had. Okay, in the present he should not have, in the past also he should not had any pecuniary relationship with promoter director of your company, promoter director of your company's holding company, promoter director of your company's subsidiary company, promoter director of your company's associate company. Next, he should also not have transaction exceeding 10% of his total income with again these same people. Okay, let's say the total income of a person whom you are going to appoint as a director, as an independent director, is 20 lakh rupees. 10% of 20 lakh rupees is 2 lakh rupees. So that person should not have or should not had any pecuniary transaction of rupees 2 lakhs or more with these people in the past or in the present, right? Next, you need to see this for the current year and preceding two financial year. Okay, these pecuniary transaction you need to see for the current year and for the past 2 years. And also, the following transactions will not come under pecuniary relationship. What are they? Remuneration that the director is taking from the company. See, the independent director is providing certain services to the company, so in return for those services he should get some remuneration, right? So that remuneration will not be treated as having a pecuniary relationship. Next, board meeting expenses reimbursement. Now every time the independent director has to attend the board meeting, for attending board meeting he will incur certain traveling charges, he will incur certain expenses. So if company reimburses those expenses to the independent director, even that should not be treated as a pecuniary relationship. Next, profit related commission. If the company gives any profit related commission to the independent director, even that should not be treated as a pecuniary relationship. Okay. Now moving to the fifth qualification. What is this fifth qualification? The person whom you are going to appoint as a independent director, the relatives of that person. See, even you need to check this independent criteria even on the relatives of that person. Relatives of the person are not holding any security or interest in the company, holding company, subsidiary company, associate company. Okay, the relatives of such a person should not should not hold any interest in such interest in the company, holding company, subsidiary company, associate company. However, there is an exception. Okay, the relatives, they can hold interest up to a value of not exceeding 50 lakh rupees. That means the relatives of the person can hold shares of the company of value not exceeding 50 lakh rupees. This 50 lakhs is face value or 2% of paid up share capital of such company. Okay, up to this amount relatives can hold the shares or interest in the company. Next, should not be indebted to the company, holding company, subsidiary company, associate company. Here, along with them, promoter and director are also added. Okay, should not be indebted to company, holding company, subsidiary company, associate company, promoter and director of those companies. The exception is indebtedness can be up to 5 lakh is allowed. Next, should not have given guarantee on behalf of third party to the company, holding company, subsidiary company, associate company, director and promoter. However, guarantee up to 50 lakh is allowed. Next, any pecuniary transaction with company, holding company, subsidiary company, associate company amounting to 2% or more of its turnover together with A, B and C. A, B and C means together with these three. Okay, together with security, indebtedness and guarantee, including these and including any other all pecuniary transactions should not exceed 2% or more of turnover of the company. Okay, again you need to check these for the current financial year as well as the two preceding financial years. That was fifth point or fifth criteria that needs to be satisfied. Okay, so here if you see, first of all, the person whom you are going to appoint as independent director should not be managing director, whole time director or the nominee director in the company. Next, he should possess integrity and he should be expert. Okay, he should be having expertise to be appointed as independent director. Next, that person should not be promoter or should not be related to promoter or director of the company, holding company, subsidiary company, associate company. Next, that person should not have any pecuniary relationship or transaction exceeding 10% of his total income, again with the company's promoter director, holding company's promoter director, subsidiary company's promoter director, associate company's promoter and director. And finally, the fifth criteria is on relatives of the person. Okay, relatives of the person should not be having any security or interest in the company. However, exception is up to 50 lakh rupees. Should not be indebted to the company, company, holding company, subsidiary company, associate company. Wherever I say company, you should include all these four. Okay, company, holding company, subsidiary company, associate company. However, indebtedness up to 5 lakh is allowed. Next, should not have given guarantee on behalf of third party to the company, subsidiary, holding company, associate company, promoter and director. However, up to 50 lakh is allowed. And along with these three, any other pecuniary transaction taken together should not exceed 2% of the total turnover of the company. Okay, you need to check this for the current financial year and the past 2 preceding financial years. Hope that is clear. Next, the sixth point is on director and his relatives. Okay, neither he nor his relatives holds or held key managerial personnel or employee of the company, holding company, subsidiary company or associate company. Key managerial personnel means KMP we will be discussing second chapter. Basically, whole time director, managing director, CEO, CFO, company secretary, all these people will be known as key managerial personnel and the company secretary. Okay, all these people they will be known as key managerial personnel. Exception, relative can be employee of the company. Okay, next, neither he nor his relative is or was employee, proprietor, partner of the firm of chartered accountants or firm of company secretaries or firm of cost auditors whom the company has appointed, or the legal firm having transaction of 10% or more of such firm's turnover. Okay, so the person whom you are going to appoint as independent director nor his relatives should not be partner or proprietor of CA firm, CS firm, cost accountant firm or any legal firm which the company has employed. Okay, here again company means you should include all the four: company, holding, subsidiary, associate. Next, should not hold 2% or more voting power of the company. Here for this only company. Okay, the person whom you are going to appoint as an independent director or the relative of such person should not hold more than 2% voting power in such company. Next, he should not be chief executive officer or he should not be director of any non-profit organization receiving 25% of its receipts from company, promoter, director, holding company, subsidiary company, associate company. Okay, basically section 8 companies or non-profit organization, they will receive funds, donations from other companies. So the person whom you are going to appoint as an independent director should not be promoter or director or director. Sorry. The person whom you are going to appoint as independent director should not be chief executive or director of such a non-profit organization which is receiving 25% of its receipts from your company or your company's holding company or your company's subsidiary company or your company's associate company or your company's director or your promoters. Hope that is clear. And he should also not be a chief executive or director of a company that holds 2% or more voting power of the company. This criteria you need to check for the preceding 3 financial years. Okay, now coming to remuneration of independent director. The remuneration of all other directors we will be discussing in second chapter. Okay, here coming to the remuneration of independent director, the independent director he is not entitled for any stock options. Okay, you cannot give any stock options as a remuneration of the independent director, because if you give stock options, the the independent director might get an interest in the company. Okay, he should be independent of the company. If he holds any shares in the company, he cannot be independent of the company. So you should not give any stock options to the independent director. And independent director can receive sitting fees. Okay, basically sitting fees is the fees that you will give to the independent director for attending the board meeting. And board meeting expenses can be reimbursed to such independent director, and profit related commission can be given. Coming to the tenure of independent director, this is important. The tenure of independent director is 5 consecutive years of 2 terms. Here one term means 5 years. So like this, the independent director can act as an independent director, the person can act as independent director of the company for 2 terms of 5 consecutive years. Okay, one term will be 5 consecutive years. Like this, he can act for 2 terms. And the cooling period is 3 years. After completing his 2 terms, for next 3 years, he cannot be again appointed as independent director of your company. Cooling period will be 3 years. Now, for the first time appointment of independent director, general meeting ordinary resolution is sufficient. But for the second time appointment of independent director, general meeting special resolution is required. That is another point. Now coming to this concept of terms, let me explain you. Let's say Reliance Industries. Now Reliance Industries has appointed Mr. A, okay, as independent director. Okay, so at the first time it has appointed him for 5 years. Okay, so first appointment is for 5 years. The first term is for 5 years. Second time it has appointed him for 3 years. Okay, so the second time appointment is for 3 years. Okay, the second time appointment is 3 years. Now Reliance Industries wanted to appoint the same Mr. A as independent director for another period of 2 years here. For another period of 2 years. I hope you are getting what I am trying to say. Okay, generally the rule is independent director can be appointed. The tenure of independent director is 5 consecutive terms of 5 consecutive years of 2 terms. Okay, so each term will be 5 consecutive years, and like this for 2 terms he can be appointed. If you see in the present situation, the first term was appointed for 5 years, and in the second term he was appointed only for 3 years. So still there is a balance of another 2 years for which he can be appointed. So now Reliance Industries wanted to appoint Mr. A for another term of 2 years. Whether it can be done or not? The answer is no, because 2 terms have already been completed. Okay, even though the term is less than for 5 years, it will be considered as one term. Okay, the first term was 5 years, that's fine. The second term was only for 2 years. Sorry, the second term was only for 3 years. Even though it is less than 5 years, it will be considered as another term, and after that term is completed, again he cannot be appointed for another 3 years. You cannot say that in the second term I have appointed him for only 3 years, so still there is 2 years balance for which I can appoint, so I will now appoint him for another 2 years. No, if you do that, it will become third term, but act says only 2 terms. Okay, even if that term is less than 5 years, it will be considered as a single term. Hope that is clear. Next, independent directors ought to be selected from data bank maintained by organization notified by central government. Basically, from where you have to select these independent directors, the central government, it will maintain a data bank. In this data bank there will be list of various qualified persons who can be appointed as an independent director. From the list of those from the from that data bank, you need to select the independent director. Hope that is clear. So that those are the provisions related to independent directors. Now moving to DIN, director identification number, section number 153 to section number 159. these sections they deal with DIN. Now there are two terminologies that you will be using. One is DIN, another one is DPIN. What is this DPIN? DIN means director identification number. DPIN means designated partner identification number. See, for director, in case of a company, you will call it as DIN. In case of a LLP, limited liability partnership, there will not be directors in the limited liability partnership, right? In the LLP, there will be partners. So the number that you will allot for the partners will be designated partner identification number, DPIN. However, DIN and DPIN number both will be same, but the terminology will be different. Okay, if you get a DIN, that same number will be considered as DPIN also. But in case of LLP, the terminology will be DPIN. In case of company, the terminology will be DIN. Hope that is clear. Now, another point is only one DIN will be given for one person. Okay, a person cannot have more than one DINs. Okay, each person will be given only one director identification number. Next, how you have to apply for this DIN? If you are getting appointed in a already incorporated company, okay, you are getting appointed as a director for the first time. Okay, in your entire life you have not acted as director of any company. For the first time you are going to get appointed as a director of a company, and that company is already incorporated. Okay, from the past 5 years or 6 years, that company has already been incorporated. So in a already existing company, you are getting appointed as a director. In this situation, there will be a form DIR3. Okay, you have to file this form DIR3 with MCA, and MCA will allot a DIN number to you. This is a scenario if you are getting appointed as a director in an already existing company. Let's say you are getting appointed as a director in a new company. Okay, the company is not yet registered. Okay, now only the company is going to be incorporated. In such new company which is not yet incorporated, you are going to get appointed as a director. In such a situation, for incorporation of a company, you will file a form, right? Spice plus form you will file. In that Spice plus form itself, if you give your details, MCA will automatically allot DIN to you along with the company incorporation. Okay, maximum of 2 directors details can be given in this Spice plus form. Okay, so along with this Spice plus form, you can get your DIN also. So these are the two ways for getting director identification number. Once you have filed DIR3, the MCA, it will verify your application, and if any defects are found in your application, it will give you a time to rectify the defects in 15 days. You need to rectify those defects in 15 days and again resubmit. After resubmission, if it is everything is okay, the central government within 1 month will allot director identification number to you. Hope that is clear. Now, on receipt of such director identification number, you have to within 30 days intimate your director identification number to the company. For such intimation, DIR 3B has to be filed, and company should also intimate that company should also intimate that director identification number which it has received from the director to ROC in DIR 3C form. Okay, it should be filed within 15 days of receipt of director identification number by the company. Okay, so once the director, the person receives DIN, he will intimate to the company in DIR 3B within 30 days that I have received this DIN. After company has got intimation of this DIN, company will intimate the same to ROC, register of company, in DIR 3C form within 15 days. Hope that is clear. And after the director has got director identification number, from there onwards, every year he has to file DIR 3 KYC. That means whether the details that you have given at the time of application for the DIN, are they same or are there any changes, like your address, your contact details. So if there is any change in those details, you need to update them on a yearly basis by filing DIR 3 KYC. Okay, So director has to file dir3 KYC every year to keep DIN active. If you don't file this dir3 KYC, your DIN will become inactive. Again, you will have to pay a penalty of 5,000 rupees to make this DIN active. That was those were the provisions related to director identification number. Now moving to section number 170, which deals with register of directors and key managerial personnel and shareholding. Basically, the company needs to maintain a register of all the directors, their details, their addresses, their contact details, okay, the date of joining of those directors. The company should also maintain a register of all the key managerial personnel and also the register of shareholders. Now these registers can be inspected by members. Members means shareholders. So members can inspect these register during the business hours and request for photocopies of these registers. Okay, members are having right to inspect these registers with the companies which the company is maintaining, and if members want, they can also take photocopies of these registers, and company shall provide those photocopies within 30 days free of cost to the members. Okay, after the members have requested for photocopies, within 30 days company has to give those photocopies within at free of cost. Nothing will be charged. If company refuses, if company refuses to make the photocopies available, or if company refuses to show these registers to the shareholders, then shareholders can make an application to register of company, which will order the company to allow for inspection. Okay, and this register should also be kept to open for inspection at every annual general meeting. Okay, at every annual general meeting, these registers should be kept at that annual general meeting so that they can be inspected by the members. Hope that is clear. So by this we have completed the discussion of the first chapter. We haven't discussed this the powers of board of directors, right? That is a simple section, you can just go through that section. Okay, I haven't given that section here. So apart from that, the entire chapter, the first chapter of set A, corporate and economic clause, got completed. We will be meeting in the next class with the second chapter. Okay, until then, take care, bye bye, see you.